What the hell happened there? That cut it short. Anyways, hi, chat. Hello. Yes, so somebody sent me something, and I think we'll open it at Locals tonight. 2.0 opened it to make sure it wasn't explosive. I checked it too. But I didn't open it and check yet. I just made sure it didn't blow up on me. So anyway, guys, welcome. We're doing Toby Madden day 4 and 5. We'll see what happens here. Like I told you guys, apparently this gets pretty good in the next 2 days, and they're super quick. They're super quick. We'll see what goes on right now. Let's see here. Why is everything? Yeah. Okay. So if you guys are ready, we're going to do this. Like I said, we'll knock out the next 2 days all at once. I hope you guys are doing well here. You guys can give me free saltine crackers. Do I look? I don't eat my own. I don't eat my own, chat. I'm not a cannibal. Wendy's has good crackers. I mean, they're crackers, but yeah. What was in the box? I don't know yet. Green Cat says Kroger's pork shoulder for $9.99 a pound. I'm going to look for that. I'm going to look for that. Is it still ticking? No. It was never ticking. So, here we are, guys. Let's get this started. You guys remember this is the forensic detective who did all the swabbing and was very into all the stuff he had done. So here we go.
Good morning again, sir.
Morning, sir.
All right, I think the last thing that we left with was I think I was getting ready to have you identify a couple of swabs.
Yes, sir.
So if I may approach you, wouldn't you? Oh, yes, sir. I'm going to show you what has been marked as state's exhibits 232 and 233. We'll start with 232 first. You tell us what state's exhibit 232 is.
State's Exhibit 232 are swabs that I obtained from the green colored vest jacket from the marker number 1 in the photographs from the lower left region of the red stain on the clothing.
Court's permission, I ask to publish state's exhibit 114. It's already been admitted.
Permission is granted.
Which is this on the 2 speeds?
Yeah.
Yeah.
You can log that, Mr. Huffman. Yeah, get this fixed.
Oh my God! What are we doing?
Region here.
There we go.
And that's where I obtained the swabs from the red stain on that clothing item.
Okay. And then with the court's permission, I'd ask you to go ahead and open State's Exhibit 232.
Permission is granted.
All right, and what is what you're holding in State's Exhibit 232?
Again, these are sterile cotton swabs that are prepackaged and sealed. Upon swabbing the red staining, I broke the seal, applied 2 drops of distilled water to each cotton swab, swabbed the red staining, put it back in this container, and then put it in an envelope to be sent off and examined by BCI.
Okay. And then State's Exhibit 233. What is State's Exhibit 233?
State's Exhibit 233 is the same swabs as 232, but from a different area. It's from marker number 2, the red staining above the tear within the fabric of the same article of clothing.
And with the court's permission, I'd ask you to open State's Exhibit 233.
Permission is granted.
And 233, again, prepackaged sterile tip cotton swabs. I swabbed the red staining in this area, identified on this article of clothing as number 2, in the same manner as number 1. Distilled water on the cotton swabs, swab the red staining, go back into its prepackage, put in this envelope, and send off to BCI for further analysis.
And if you would, Detective, I know you testified a little bit about this today, but if you could refresh some of the recollections of the jurors. What sort of training have you undergone in order to take swabs like this from items of evidence that you're just describing?
So I've actually taken an online training that was presented by the Ohio Attorney General's Office and by BCI with their clear instructions of how to properly collect and swab samples such as these according to the policies and procedures. So I'm following the policies and procedures that BCI would employ at their crime lab, but I'm doing so with the instructions from them from the training I received here in-house at our headquarters.
Okay. And then, if I can approach the
Okay.
where was the area of witness? So you said you took a swab from this area right here.
Yes, sir.
Okay. And then the other one is from this area right here.
Yes, sir.
Is there a particular reason, or why did you pick those 2 areas?
I'd actually collected swabs from all 5 identifiers on the front of the clothing, and I had taken the sterile scraping of the dry substance on the back of the clothing. When coordinating with BCI about what they felt was best to initially submit, they wanted me to just submit the swabs from identifier number 1 as State's Exhibit 232 and swabs from identifier number 2, State's Exhibit 233, along with submitting the entire article of clothing. So that was their recommendation.
Okay, so it wasn't necessarily your decision. It was sort of a collective effort of many individuals in order to determine which swabs to send up there.
Yes, sir.
Okay. And then when swabs are taken from items of evidence, like we see in State's Exhibit 114, what do you do with the swabs?
I package them sterilely and submit them online through a portal to BCI, and it is transported up to BCI.
I would assume that, I'm sorry, I shot that.
It's hand delivered.
And I assume once those items are taken, once those swabs are taken from the item, it's contained in State's Exhibit 114, I assume those swabs are kept at the Hamilton Police Department, like in a property room?
Yes, sir, they are.
Okay. Again, that property room is secure. Only certain people would have access to the property room?
Yes, sir. I don't even have access to the property room, so I turn it over to another individual who securely has access.
And then the items would be taken to BCI by, I believe it's a rotation of different detectives. Detective each week would take any items up to BCI that need to be taken.
Yes, it is hand delivered by one of us to maintain that chain of custody.
Okay. And with the court's permission, if I can display State's Exhibit 132. I think it's already been admitted.
No problem. Permission is granted.
All right, so what are we looking at here in State's Exhibit 132, Detective?
After I collected swabs from each of the identifiers on the clothing, I then applied Blue Star in the same manner as I did in the sink in the bathroom at 1270 Parish Avenue to this article of clothing. Again, it appeared to me that the red staining on the article of clothing resembled that of blood. I applied Blue Star to see if I would get the same reaction as I would have in the sink and get the same chemiluminescent reaction as an indication for the potential presence or likelihood of blood being present. And when I applied Blue Star to identifier number 1 here, that was the reaction that I received, that there was a high likelihood that the red staining on the article of clothing was blood. I also applied it to be able to show the contrast between the stain and the color of the green jacket. It was kind of hard to see in its natural state. So this highlights the difference in location of where I obtained the swabs as well.
Okay. And you would have taken the swabs first.
Correct.
And then applied the Blue Star.
Yes.
Okay. State's Exhibit 133. What are we looking at here, Detective?
It is the same application of Blue Star, but it is on identifier number 2. I apologize, you can't see the identifier number 2 as clearly as number 1, but that is because the clothing item had folded when I was spraying it. But again, this is where I took swabs prior to the application of Blue Star and got the same reaction as I observed in number 1.
134.
This is identifier number 3 on the same clothing item. Again, with the application of Blue Star, I received the same chemiluminescent reaction, indicating that there was a high likelihood of blood being present from the area where I obtained the swabs.
And then 135.
Identifier number 4, again, same reaction to Blue Star from the area where I collected the swabs from this particular location on the same clothing item.
And then 136.
Number 5, again, collected swabs from this general area. Administered Blue Star afterwards. We've seen the same reaction with a high likelihood of presence of blood.
And then 137.
137 is the rear of the clothing item behind the left armpit. This was not a swab. Again, number 6 was a red stain, a substance that had dried and flaked. And so I took a sterile scalpel. Again, it's prepackaged like you would the cotton swabs. And I was able to scrape that off into a druggish fold paper, package that to an envelope, much like the ones for States Exhibit 232 and 233. Once that was collected, I still, like Blue Star, got the same chemiluminescent reaction with a high likelihood that blood was present.
Thanks for being here, Vicky.
And Detective, what I would ask the court's permission, and I believe you've already identified States Exhibit 2, but I'm going to take out 2 of those. And I know some of the tags have fallen off. So the court's permission, I can have the detective step down and I would ask him to point on the actual exhibit itself. Where,
Yes.
Region.
Yes, that is the part that's like everything's online training now, and it's like, why isn't this in person?
Number 1, 2, 3, 4, 5, and 6.
Permission is granted.
So again, a lot of the identifiers have fallen off because I manipulated it, DCI manipulated it, based on their own analysis. It got sent back to us. We did another analysis of some areas. Phase 1, the present in the lower left region of this general location.
I hope not.
2, again, the general location of the cut mark. 3, as you can see, is still attached. So it's right here on the chest pocket with the zipper. 4 is over here, lower right region. 5 was upper right region. And then if you flip around to 6 on the rear, the left armpit, right here, where I'm indicating my best center, around 6.
Thank you, Detective. If I may approach the witness.
You may.
Detective, I'll hand you what's marked as States Exhibit 218. I guess if you would, Detective, can you tell us what is in States Exhibit 218, the first night I gave you?
You want me to remove it from the bag?
Yes, please.
Okay. States Exhibit 218 is a dark colored gray button-up shirt. It was recovered on the second search warrant conducted on the residence. However, it was located during the first search warrant on the residence, but we did not know its interpretive value. We did not know it was evidence until the second search warrant on the residence where we recovered it.
Okay. If you hold up States Exhibit 218 with the court's permission.
Permission is granted.
It's a short sleeve button-up Dickies gray shirt.
Thank you, Detective. And I'll probably be asking you to hold that here in a second. If I can direct you to the exhibit book. I'm going to ask you to look at States Exhibits 138 through 146.
Okay.
Ooh, interesting. I didn't know that.
And generally speaking, what are we looking at in States Exhibits 138 through 146?
States Exhibit 138 through 146 are photographs that I collected of the same shirt that I just showed before you, where I identified numerous evidence of red staining on this clothing item. I did not identify all because there were too many, but there were numerous where I was able to locate on this gray shirt.
All right, in States Exhibit 138 through 146, are all those photos that you took?
Yes, they are.
Okay. Are those photos true, fair, and accurate as to your visual observations you were making of this gray shirt when you took the photos?
Yes, sir, they are.
Your Honor, I would ask that 138 through 146 be admitted and permission to publish.
Any objection?
No objection.
All right, they'll be admitted and they may be published.
All right, what are we looking at in States Exhibit 138?
States Exhibit 138 is the gray shirt. And you can see that's just a photograph of it in its natural state.
And I know that you and I talked about this before. I know when looking at the photo, the shirt kind of looks green, doesn't it?
It does, yes. And that could be because of the lighting that we have at the department.
Okay, but the picture that we're looking at in States Exhibit 138 is in fact the shirt that is on the floor behind you, on the ground behind you, which is States Exhibit 218.
Yes, sir, it is. It's the same shirt.
Okay, and I guess with the board's permission, if you'd like to stand up and show the different tags. So I know there's a tag up top and there's a tag towards the bottom of the shirt.
Permission is granted.
You can see
If you'd like to stand in front of the shirt, please.
inside the collar at the bottom of the shirt, the same manufacturer identifiers.
Okay. And inside the collar there is also Dickies and,
There is
let's say Dickies and Flex.
Dickies Flex.
Okay. Thank you, Detective. I'll get a tag from after a minute. All right, State's Exhibit 139. What are we looking at here in State's Exhibit 139?
This is the same shirt, but just generally, these are locations where I identified what appeared to be blood stains, or red stains, if you will, on the front of the shirt. It is not all of them. It is just what was most apparent.
All right. State's Exhibit 140.
It's a close-up photograph. Same. It's showing identifiers 1, 2, 3, 4, 5 on the right-hand side. Or sorry, that would be the right-hand side in the photo, but it's the left side of the shirt. And then 19, 20, 21 on the right-hand side of the shirt, but it's the left-hand side when viewing photographs.
State's Exhibit 141.
This is the upper portion of the shirt with also the left sleeve. You can see number 5 there in the lower portion of the photograph connecting the two images. Again, it's just another picture of the different identifiers that I've marked on the shirt.
State's Exhibit 142.
And this is showing the right sleeve and the identifiers that I marked there that appear to resemble that of red staining or blood.
The right sleeve with the left side of the
Photograph. Yes, it is. You have to flip it in your mind.
All right, 143.
So these are close-up photographs of certain markers that I identified, number 2, 3, and 5. You can see the red stain in more detail.
State's Exhibit 144.
And this is the right sleeve. Well, yes, the right sleeve, but in the photograph it looks like it's on the left side.
We've only been on for like 15 minutes, and you haven't missed anything, Jude, so don't worry. Like, it's the guy digging through exhibits still. It's still that same the evidence detective from earlier, so don't worry about it. You haven't missed anything, except looks like some of the stuff he stabbed through when he stabbed her.
Where you have identifiers number 13 and 14 that were marked.
State's Exhibit 145.
Thank you, Cindy.
This is the back of the shirt, as is in its natural state.
And 146.
And this is where I identified just generally 3 locations of where that red staining appeared to be. As you can see now from the back, the right sleeve is on the correct side of the screen, it's on the right side. And then the left side over there, identifier, this one would be on the left side on the shirt.
And if I may approach the witness.
You may.
I'm going to hand you what has been marked State's Exhibit 234 and 235. And what is State's Exhibit 234?
State's Exhibit 234 are swabs of the red staining that I collected from identifier number 3 on the front of this same shirt within the lower left edge.
And then State's Exhibit 235.
And 235 are blood swabs taken from identifier number 14, which was the right sleeve of the shirt on the front portion.
All right, so in State's Exhibit 140 that's on the screen behind you,
Yes, sir.
worded swab, which is contained in State's Exhibit 234. Where did that come from?
From this location, identifier number 3.
So left side of the shirt with right side on the State's Exhibit.
Correct.
Okay. And then where did swab 235 come from?
235 is going to be in a different State's Exhibit photograph because it's on the right sleeve.
Which was probably 142, probably.
Yes. So State's Exhibit 142, I have 13 and 14 on the right sleeve, but 14 specifically was this location here, swabs of the red staining that are contained within State's Exhibit 235.
All right, and I assume that, or actually, again, explain to ladies and gentlemen of the jury here, what it is you did to take swab. The swabs are contained in State's Exhibit 234 and 235. Explain how it is again that you did that.
Yes, so it's done in the same process as swabs from the green vest. I collected them individually and separately. So State's Exhibit 234 was collected, again, with prepackaged sterile cotton swabs, where distilled water was applied to the cotton swabs. I swabbed that area of staining, collecting it, putting it back in its prepackaged container, putting it in an envelope to send to BCI, and 235 was collected in the same manner, but from a different and separate region. It was collected from number 14 on the shirt.
And I assume that this would have been done at a different time than the jacket to make sure that there's no cross-contamination that was done.
Yes, absolutely. I believe everything was collected and swabbed on the same day. However, the jacket was swabbed and collected first, repackaged. I changed PPE, I reapplied PPE, gloves, and then handled the shirt separately away from the green vest. So there was no cross-contamination issue.
And what is PPE?
Personal protection equipment, gloves, goggles, masks.
Okay. And then with the court's permission, I asked the detective to step down with State's Exhibit 218. Now I'd ask him to demonstrate on the actual exhibit, since probably several of the flags have fallen off, on the actual exhibit itself, where State's Exhibit 234, where that swab came from, and State's Exhibit 235.
Permission is granted.
So some of the stickers that are in place on the shirt have been moved. So the stickers that you can't see, don't think that that's where they are. Whatever's in the photograph, that's where they are. You can see what stuff. So State's Exhibit 234, very faint, which you can see here, as it wraps around the left side of the shirt, which would be kind of the side where you have the seam. That's where that swab was collected, that State's Exhibit. And on the front here, number 14 was right here on the right sleeve of the shirt. And differentiate different versions up here. Number 14 is happy with the companies.
Thank you, detective. And again, how was it decided that those would be the two swabs, swab 234, or swab that's in State's Exhibit 234 and the swab contained in State's Exhibit 235? How was that decision arrived at to send, or to swab those areas and or to send that up to the lab?
Again, I spoke with the analysts and scientists at BCI. I gave them the pictures and documentation of this shirt, and it was their determination that
Sustained.
In consultation with BCI, is that why it is that you sent up those particular swabs?
Yes, sir, it is.
All right. I think you have the book. You have the books in front of you. If you would please flip to State's Exhibits 158 through 166.
Okay.
And generally speaking, what is it that we're looking at in State's Exhibits 158 through 166?
So these series of State's exhibits were conducted after BCI had performed their analysis. Okay. And there's a particular reason why I say that and we'll get to that. But these are photographs that I collected of the green vest here in State's Exhibit 158, which we will more closely view the tear in the green vest jacket.
Right, so generally speaking, these are, again, photos of the green vest jacket.
Yes.
Okay. Are those photos that you took?
Yes, they are.
True, fair, and accurate depictions of what it is that you're looking at when these photographs were taken?
Yes, sir.
Okay. All right, I ask that 158 through 166 be admitted in permission to publish.
Any objection?
No objection.
Okay, they'll be admitted and they may be published.
All right. And Detective, what is it that we're looking at here in State's Exhibit 158?
State's Exhibit 158 is the green vest jacket, just kind of like an overview of the tear next to identifying number 2.
If you would, so in these photographs, we're going to be looking at the tear that's in the vest, is that correct?
Yes, sir.
And if you wouldn't mind, go ahead and circle the tear it is that you're visually seeing in State's Exhibit 158. State's Exhibit 159.
So this is a close-up photograph of the tear. Now, in order to be able to take this photograph and represent it as best as I could as the fabric naturally lays and be able to see the uniqueness of that tear, I had to insert a piece of printer paper between the front and the back of the clothing item so you could actually see what that tear looked like as it lay flat. Otherwise, it would blend in with the background of the vest through the tear. You wouldn't see it as well.
And these photographs were taken well after these items were sent off to the lab for testing and they were brought back to the Hamilton Police Department?
Yes, after the department and the prosecutor's office had spoke, we had decided that there was no more analysis to be performed by BCI, and that we were given permission to handle said items in this manner.
State's Exhibit 160.
So, State's Exhibit 160.
And let me stop you there, Detective. Let me approach the witness.
You may.
Yes.
I believe we looked at this yesterday, but State's Exhibit 215. Again, what is State's Exhibit 215?
State's Exhibit 215 is the Swiss Army knife, a multi-tool knife that was recovered from the residence.
Okay. And what is it that we're looking at in State's Exhibit 160 then?
I was asked to see if there was any correlation between the first blade attachment, where the blade was broken in some manner, and see if it correlated in any way or resembled in any way the tear that was observed on the green vest jacket.
And that's why it is you took this particular photograph?
Correct.
State's Exhibit 161.
Again, this is just another angle of how this uniqueness of the defect of the blade could have some similarities within the tear within that clothing.
162.
So again, with permission to handle these items in this manner, I inserted the knife between the front of the green vest jacket and the rear to be able to show maybe how the uniqueness of the blade defect could have caused this tear in this jacket, and is lined up as so.
State's Exhibit 163.
That is the orientation in which I took the photograph as observed in State's Exhibit 162, the one you just saw before. So that's how it was oriented and aligned as best as possible.
State's Exhibit 164.
So State's Exhibit 164, again, with permission to handle said items of evidence, we aligned the gray shirt inside of the green vest as one would normally wear it to see if there were any correlations as how it was aligned on someone's body if being worn together.
State's Exhibit 165.
And as you can see, I have then aligned the blade again to kind of demonstrate that uniqueness of the tear in the green vest jacket with the gray shirt inserted between.
And then 166.
And as an overall view of all the items combined with the blade itself having been inserted between the clothing items to kind of show the edge of the blade as having cut through the green vest.
All right, thank you, Detective. And then you have the exhibit book in front of you. I'd ask you to look at State's Exhibits 167 through 176.
Okay.
And generally speaking, what are we looking at in State's Exhibits 167 through 176?
These are photographs of the deceased victim's shirt where multiple tears were observed. And again, I was asked to see if there were any similarities with the multi-tool and specifically with the first blade attachment with the defected blade to see if anything lined up.
Again, are those photographs that you took
Yes, they are.
true, fair, and accurate depictions of what it is that you were looking at?
Yes, sir.
I'd ask the 167 through 176 be admitted and permission to publish.
Any objection?
No objection.
All right, they'll be admitted and they may be published. You may.
As observed in the photograph above.
So then what are we looking at in State's Exhibit 167?
That is the victim's shirt laid out flat as best as possible. It's in front of it.
State's Exhibit 168.
I am on the
Exhibit
phone. I'll be right
168
back,
is a-
guys.
Tear within the victim's shirt. Again, I was asked to see if there were any similarities between any of the tears in the victim's shirt with that unique first blade attachment of the multi-tool or Swiss Army knife.
State's Exhibit 169.
So that is a close-up view of one of the tears. I identified it as tear number 1 in the photograph, as State's Exhibit 168 depicted. This is a close-up photograph of this.
State's Exhibit 170.
This is with that multi-tool and the first blade attachment has the piece that's missing from the blade aligned with the tear in this fabric.
State's Exhibit 171.
This is a second tear, identified as tear number 2 within the victim's shirt.
All right, and if I can put you
Yeah.
here. If you're able to, Detective, State's Exhibit 210, can you show us on the actual shirt itself, State's Exhibit 210, where that photograph is taken of?
Yes.
And with the board's permission, I ask the detective to be able to step down and show the jury.
Permission is granted.
front of the victim's shirt,
If you need help, let me know.
and I took that photograph from this tear right here. You can see my thumb. That's exhibit 102.
Is that the bottom left part of the shirt?
It is. It is.
You can go and step down and make sure all the jurors are able to see that.
Again, I had to insert a piece of printer paper in the front and the back of the shirt, so you can better visualize the layout of the tear. That's the flat.
And State's Exhibit 172.
It's a close-up photograph of the tear identified as number 2 in the previous exhibit.
State's Exhibit 173.
And this is how it was aligned when that first blade attachment, with the piece missing in the multi-tool, appeared.
State's Exhibit 174.
This is tear number 4. That's on the victim's shirt.
And with the court's permission, Detective, are you able to show on the shirt where exhibit number 4, the arrow is on the shirt?
Give me a minute to look through them all.
If you're not too sure, it's okay.
Yeah, I don't want to take up too much of the court's time. It is fairly difficult to relocate. Oh, I have located it. Identifier number 4 is actually a tear. This is the left side of the shirt. Here's the chain of my thumb. It's not necessarily on the front of the shirt. There's one towards the left side. Again, if you would as best as possible, insert a piece of paper, so you can see in contrast with the background color of the center.
Thank you, Detective. State's Exhibit 175.
Again, this is the tear identified as number 4 in the previous exhibit, but with the same blade attachment, kind of aligned above the tear in the fabric.
And State's Exhibit 176.
And the same tear identified as number 4, but with the blade attachment not aligned above, but over top of the tear in the fabric.
All right, thank you, Detective. And if I may push the windshield.
You may.
Go ahead. I think we're done with this. So we can- I think I neglected to ask you, going back to State's Exhibit 234 and 235, I believe you identified those, the swabs that you took from the gray shirt. With the court's permission, if I can ask you to first open State's Exhibit 234.
Permission's granted.
And 234, State's Exhibit, again, prepackaged sterile swabs, cotton swabs, that were taken from region number 3 of the gray shirt. Okay, so that's kind of like the lower left portion of the gray shirt. Again, I applied a couple drops of distilled water to each swab, rubbed the red staining, put the cotton swabs back in its original packaging, and prepackaged it in an envelope to be sent to BCI.
And on State's Exhibit 235, with the court's permission, I ask you to open 235.
Permission's granted.
And State's Exhibit 235. Same process of collection of the red staining as State's Exhibit 234, prepackaged cotton swabs, distilled water applied to each swab, collected from the red staining of region number 14, which would have been the portion of the right sleeve on the front near the cuff. That was then put back in its original packaging, put into an envelope, and sent to BCI.
And likewise with the other two swabs, 232 and 233, those would have been at the Hamilton Police Department in the property room.
Yes, sir.
Again, only certain people would have access to that property,
Yes, sir.
and would have been taken up to BCI for testing.
Yes, sir.
And I think, ladies and gentlemen, the jury have heard a little bit about this. But Detective, were you assigned to a breaking and entering / burglary type offense that allegedly occurred at 1270 Parish Avenue on, I believe the date would have been October 6th of 2022?
Yes, I was.
Okay. Tell us how it is that you were assigned that particular case.
The defendant, Toby Madden, had made an offense report to Officer Bryant that I had been assigned for follow-up.
And what do you mean by follow-up?
I was assigned to reach out to Mr. Madden to kind of identify if there were any alleged suspects involved with the breaking and entering of the residence at 1270 Parish Avenue.
Okay. And what methods did you use, or how did you attempt to make contact with Toby Madden as a follow-up?
Yeah, so on the offense report that P.O. Bryant had filed, he had gathered.
Objection.
Yes.
Information from the report.
My question was, what methods or how did you use to make contact with Toby Madden?
So using the information from the report, phone number, address, I attempted to make contact by calling the listed phone number on the offense report to speak with Mr. Madden. I received no answer after calling twice. I then left my business card with my name, identifying that I was a detective with the City of Hampton Police Department at the residence
Of 1270 Parish?
of 1270 Parish. The report, though, indicated an incorrect address for Mr. Madden, said he resided at 250 Brookwood Avenue, which is not a good address for the defendant. The offense report was made for 1270 Parish Avenue. That's where I responded to in an attempt to speak with Mr. Madden and leaving my card. After having left my card, I still never received a call or contact from Mr. Madden himself, and I made the case inactive until further, until he made attempts to reach out to me.
If I can have probably 2 or 3 moments, John.
Yes, sir.
Give 1 second, John.
Good morning, Detective.
Good morning, sir.
I want to talk to you with this, the alleged burglary incident you just spoke of. Is there a chance you didn't have the correct number when trying to contact Mr. Madden?
To be honest with you, whatever number I was given was the one I attempted to make contact with. I received no contact. That's why I made a personal appearance to drop my card in case the number was wrong.
Okay.
You could contact me with the correct number.
Sure. But my original question is there a chance you had the wrong number?
Yes, the phone number could have been documented incorrectly by the reporting officer.
And the reporting officer on that was Taylor Bryant, correct?
Yes, sir.
And did you review his report before you came into court today?
Yes, I've reviewed that report.
And were you, at the time, were you a detective assigned to that specific burglary that occurred 5 days before?
Yes, I was.
Is it your understanding that Officer Bryant responded to the scene
Yes, he did.
and took photos?
Yes, sir.
And does his report indicate that there was damage to the back door?
Yes, it does.
Did you have any contact with anybody else at 1270 Parish, such as Rachelle?
No, I did not.
And you never spoke or saw Mr. Madden in relation to the burglary 5 days before?
No, sir.
Did you yourself go out to 1270 Parish and look at the property or the door at all?
I didn't know. I try to make contact with residents there before going to the back of the residence, make my appearance known that, hey, I'm law enforcement. I'm not somebody just wandering about the backyard. So I did not go to the rear of the residence and inspect the damage as reported.
Okay,
I just went to the residence to try and make contact with a homeowner or a resident there.
sure. And Detective, you can't do every single thing possible in a case. Sometimes you have to rely on reporting officers or patrolmen to do certain things for you and give you this evidence for you to follow up on if you need to. Is that kind of fair?
Yes, sir.
I want to start with regards to the incident that ends up happening 5 days later. The knife, if the state would mind, since they're connected to the overhead, if you could put 150 up for me, please. Yeah. Detective, where did this knife come from within the parish residence?
It was located within the deceased victim's black backpack.
To your knowledge, was that black backpack, was it zipped up or buttoned up in any way?
I can't recall if it was zipped up or secured in any way.
Okay. Now, you testified that you observed this knife and you thought that there may be some sort of residue or some sort of wiping on this. Is that what you testified to?
Yes.
Now, you've shown us the fluorescent blue star that you used on other things, the sink, we saw it on the vest. Why did you never use the blue star on this knife to see if there was presence of blood on this?
That's because, again, this was a critical piece of evidence. So you kind of have to weigh the results of some tests being performed versus what your results may be. Knowing that this was a critical piece of evidence that might have minimal But sufficient important evidence to this case, I did not want to interrupt any DNA typing or analysis conducted by BCI by introducing Blue Star. Blue Star is a tool, it's a screening tool that you can use if you have sufficient evidence to use it. Here, I did not want to use it on such a critical piece of item of evidence. I just wanted to document it and submit it to the lab so they could do their own analysis in a more sterile environment.
I thought you testified though about Blue Star that doesn't interrupt blood presence if it's there. I thought you said that to us.
Yes, you are right. It does not interrupt DNA typing or analysis. But again, you want to be able to have sufficient evidence to document the presence of blood. And on such a small knife blade, I don't want to apply Blue Star by overspraying and causing any DNA or blood that could have been present to fall off of the blade onto the sterile cardboard sheet below, and therefore losing that value of any evidence or potential evidence.
Good. And the determination and maybe the conclusion of whether or not this blade has blood on it, that's for a DNA expert from BCI, is that fair?
Yes, sir.
Were there any photos of this knife sent to the coroner?
If there were, I did not send them. I do not know.
Okay, that wasn't something you were involved with?
No, sir.
Do you recall, well, you weren't recorded. The coroner referenced maybe possibly having a photo of a knife, but you're saying you weren't involved with that?
No, sir, I was not.
Did you attend the autopsy?
No, I did not.
Is it a common practice for someone within your department or your agency to attend the autopsy?
That depends upon the coroner. I guess it's a case by case. Sometimes we're allowed to attend, and sometimes we're not allowed to attend. But I did not attend.
To your knowledge, within the residence during these searches, were there any rags, towels, paper towels covered in blood recovered?
Not that were apparent or observed at the scene.
If the state could please pull up 77. Detective, this is one of the exhibits that you testified to, I believe it was yesterday. So the fluorescent that we're seeing here is indicating that there's blood that was present at some point. Is that fair?
Yes, it is a screening tool that gives you with a high degree of certainty that within the fluorescence that there is a high likelihood that blood is present.
Okay. And you would agree with me that a sink is normally a place where you're going to wash your hands, correct?
That is correct.
And would you agree with me that if you had placed your hands on someone's body to perhaps give CPR, that you might end up with blood on your hands?
That is correct.
Are we able to tell from this fluorescent imaging whether someone washed their hands, but then they try to wipe any and everything away from the sink? Can we tell that from this image?
No, I don't see any apparent, if you're asking for like smears or wipes.
Because what I want to ask is if someone washed their hands in the sink and there's blood that falls in the sink, the water takes most of the blood down into the sink, but then someone wants to then take a rag, kind of wipe the bowl out, wipe the edges. Would this fluorescent that we see in State's Exhibit 77, would it appear differently? Would it have swirls and motions like that for the blood?
I don't know if it would or not, to be honest with you. I just know how to detect its presence and recognize its appearance with the reaction. I don't know if it would show a smear.
Okay. Well, during your training with Blue Star, did they not cover something like that we can not only detect where blood has dropped, but we can also tell if someone has tried to wipe blood away? Is that not part of the training?
No, I'm sure you could be able to indicate if something has been wiped up, but specifically, no, that was not covered in any of the trainings that I was a part of.
So you're telling me this picture is going to appear that way, whether the blood just was washed off hands, went down the sink, or if someone sat there and you literally used the towel to try to wipe everything up. You can't tell us if this picture would be different if someone tried to wipe all that away?
Oh, no, I'm sure it has the possibility of appearing different, yes.
Just a possibility? You don't think it would show swirls in this picture if someone used the towel?
I haven't been a part of any type of practical examination of that,
Okay.
but it is possible, yes.
You were involved with some of the searches at the property, correct?
Yes, I was there.
Were you involved with the search of Rachelle's car at the residence?
I did not search the victim's car.
Okay, so you would not be aware that rifles were found inside her car?
I was not a part of that search.
The state wouldn't mind putting Exhibit 160 up. When I talked about State's Exhibit 160, you were talking about the knife and you were talking about some of the cuts within the vest. You've handled not only the vest and the knife. You see pictures of it, you were there, you've analyzed it. Would you agree with me that the vest and the knife are not new?
Are not new.
Meaning like they don't appear that they were recently purchased. They appear old. It's not like they were 1 week old, like they've just been bought.
I can't date the appearance of clothing when it was purchased versus if it's worn, and same thing with a knife.
You can't tell does that knife appear to be new?
It doesn't appear to be brand new, but I'm not going to date it.
Does that appear to be rust on the knife?
Yeah, there could be indications of rust on the knife.
I mean, common knowledge, rust doesn't appear just overnight, right?
Right.
Takes a long time.
I don't, again,
Just off your common everyday knowledge with things you have in your house or you've been around, it takes a long time for rust to set in. Is that fair?
I would say it does take time for rust to set in.
Okay.
Yes.
When you're testifying about the cut in this vest, you said you had to put a piece of white paper underneath it to see it, correct?
Yes, because the background behind the cut is the same as the foreground, so it blends in. So yeah, I had to put a piece of paper in between so you can see the actual layout of the tear in the fabric.
So this, in order to find this cut and to look at it, you had to get pretty close to it. Is that fair?
Yes.
So if there was an angle from a Kroger video up on a ceiling, there's a chance it might not capture a cut that's in a vest. Is that fair?
That depends on the quality of the camera.
Well, true. You do agree with me that you need a piece of copy paper just to see the cut up close, right?
I think it highlights the difference. It contrasts it. You can see the cut. I could pull the article of item out and the jury and everybody here would see the location of where the cut is. But to see it more thoroughly as what its design is, you need to highlight and contrast the differences between the front of the vest and the back of the vest. So,
And we don't know how long that cut's been on that vest. Is that fair?
I don't have a way to date how long that cut's been there.
All right, that's all. Give me 1 second. Defer. Nothing further, Judge.
Okay, thank you. Can you redirect?
Hold on.
Okay.
Let's see if that's all right. Sure. Sir, did you do any kind of blue star illumination on the back door or near the back door?
No, I did not.
Was there any thing you did to try to observe or find out if there was any blood or other evidence at that back door?
The back door was locked with both doorknobs. I didn't have an indication that it had been opened at the time that I responded for the first search warrant on the day of the incident. So no, I did not.
But you were aware that 5 days before a burglary had been reported at that back door?
Yes.
Nothing further.
Can you redirect?
Again, it was just reported. There's no follow-up that was able to be done because you couldn't make contact with him.
That is correct.
Thank you.
Okay. Thank you, Detective. You may sit down. Okay. State ready to call his next witness.
First of all, I believe Detective Trenum can be released from the state subpoena under Mr. Willoughby.
I'm sorry, Judge.
Detective Trenum be called.
No.
Okay, that's one reason from us. No, this might be good. I know it's a little early. This might be a good mid-morning break time because I think the next witness will be here.
Okay. And let's go ahead. Thank you for that. Let's go ahead and take our break. It's about 9:40. We'll take 15 minutes and come back at 9:55. Please remember my recess instructions.
Guys, I'm trying to finish up here real quick, but we're going to skip ahead on the break here. Sorry.
The conclusion of the state's case. And getting further along in the case, I'd like counsel to be prepared to have our first discussion about those at the conclusion of the state's case. I anticipate we'll have additional conversations, but just to get a start on that after we've at least heard the state's case. Other than that, is there anything from the state before we take our break?
I anticipate 2 more witnesses, Catherine Daly from BCI and Tanya Cook.
Thank you for that. Mr. Wilder?
Judge, we still on the path of stopping at 12 like yesterday? Is that still
Yes, sir.
today?
Yes, sir.
And that includes anything, even with instructions or other things, we're dropping at 12?
Pretty close to. If we need just a few minutes, I can spare that, but any lengthy discussions we'll have to have about tomorrow.
Okay.
And to be, hold on, that's not sure.
Okay, all right. We'll be back then at 9:55. Thank you.
Yes, I think you said I would call Catherine Daly. Appreciate you being here. Would you please state your name for the record and spell your first and last name?
Yes, my name is Catherine Daly. First name is spelled Katharine. Last name Daly, Dailey.
And where are you currently employed?
I'm currently employed at the Ohio Bureau of Criminal Investigations. It's commonly referred to as BCI.
Okay. And what is BCI?
BCI is a law enforcement agency that will assist various other local law enforcement agencies in the investigation of crimes.
Okay. And is there a particular section of BCI that you work for?
Yes, I work in the laboratory section, specifically in the DNA section.
Okay. And what would be your job title at BCI?
I'm a forensic scientist.
And explain to the ladies and gentlemen of the jury what it means to be a forensic scientist.
A forensic scientist will look at items of evidence and collect samples for different types of analyses. In my case, collect samples for DNA analysis.
Okay. And in regards to your employment at BCI, being a forensic scientist in the DNA section, are you assigned to the DNA section?
Yes.
Okay. So then in regards to your employment being a forensic scientist in the DNA section, would you please describe to the ladies and gentlemen of the jury your education, your background and training in order to achieve such a position?
Yes, I have a Bachelor of Science degree. My degree was from Ohio University in Athens, Ohio. My major was in microbiology and my minor was in chemistry. And upon being hired at BCI, I underwent a year-long training program that included mock cases, lectures, online coursework through West Virginia State University, reading of forensic articles, journal articles, and lots of other things as well.
Okay. And how long have you been assigned to the DNA session at BCI?
I started in December of 2011, so I'm coming up on 13 years.
And on prior occasions, have you had the opportunity to conduct testing for DNA on different evidentiary items that have been submitted to BCI?
Yes, I have.
Okay. Have you any idea how many times you've run such tests?
Thousands of times.
And based on the thousands of times that you have conducted these types of tests, have you been able to make either a positive identification or I guess not an identification based on the testing experience you have run on evidentiary items submitted to your lab?
Yes, I have.
Okay. And if I use the phrase inclusions, what does that mean to you?
If someone is determined to be included in a DNA profile, that means that their DNA profile that we obtain from a known standard is consistent with that of a DNA profile obtained from an evidence item.
Okay. And if I use the phrase exclusion, what would that mean?
That means when making those two comparisons again between the known DNA standard and a DNA profile from an evidence item, at least one of the locations that we're looking at on that DNA profile is not consistent.
Okay. And have you previously been qualified as an expert in forensic science in the courts of law, first of all, here in the state of Ohio?
Yes,
How many times would you say that you have been?
it's upwards of 80 times.
Okay. And how about outside the state of Ohio or including the federal system? Have you been called to testify as an expert as well in either other states or in the federal system?
Guys, for locals tonight, the promo code is not guilty. And yes, tonight on locals, we'll be doing an unboxing because somebody sent me something, a rather large box. And I think I know who it came from based on where it came. It came out of Chicago. So I think if you're there, that's yeah. So if you're here, we'll take a look at it.
In the federal system, yes.
Okay. How many times would you say you testified in the federal system?
One time that I can recall offhand.
Okay. Now, you're talking the state of Ohio goes in the federal system?
Yes.
Okay. At this point, Your Honor, I would tender Ms. Daly as an expert in forensic science as it relates to DNA analysis.
Mr. Robert?
Judge, no vote aye for this witness, no objection.
Very well. Witness will be so qualified.
Okay, thank you, Your Honor. Ms. Daly, it's my understanding that you were asked to compare various items in the cases before this court in regards to DNA, is that correct?
Yes, that's correct.
And as part of the comparison process that I'm going to have you talk about, generally speaking, can you educate the ladies and gentlemen of the jury as to how it is evidence arrives at your laboratory at BCI?
Yes, a local law enforcement agency will bring the evidence to our laboratory, and our evidence receiving staff will take in that evidence. It's assigned a unique case number, and each item of evidence is given a unique item number. These are tracked throughout the laboratory via barcodes, and they're placed in a secure vault until analysis is to be done on those items of evidence.
Okay, so, if I may approach you,
You may.
hopefully it'll be an item that's on the screen behind you. This is going to be, just for purposes, this is to be State's Exhibit 234. And just generally speaking, there's a kind of a light purplish type label that is on this particular exhibit. Can you just explain what it is that we're looking at here to maybe start talking about barcodes and things like that? So what is indicated on this particular exhibit?
So this purple barcode that is on this item will tell us what the BCI lab number associated with this item of evidence in this case is. It also tells us what the BCI item number is. At the top, it says item 15. It'll tell us what agency submitted that item, as well as their agency case number. And this is the barcode that would be used to track that evidence item throughout the laboratory. So for instance, when I would take this item of evidence into my custody, I also have a barcode that's assigned to me. So this would track it in the computer system saying that it's in my custody.
Okay. And I would assume that each case would have a unique lab number, is that correct?
Yes, that's right.
Okay, and then, but if there's multiple items that are submitted under the same lab number, that's how we get item number 1, 2, 3, 4, 5, all the way up to however many items BCI winds up getting.
That's correct.
Okay, and I would assume that when items are submitted to BCI, where would they be stored? Obviously prior to testing and then stored after testing.
They're secured in a evidence vault.
Okay, and again, I assume that not just anybody has access to the evidence vault. There's only certain people who will be allowed to go into the evidence vault.
Yes, it's limited access.
Okay, and I would assume that there has to be some sort of code punched in order to go into the vault to obtain items.
Yes, in order to obtain those items, you have to scan a card as well as punch in a specific number to the individual that's trying to get into the vault.
Okay. I'm going to take this down for now. So how is it that you're able to ensure the integrity of evidence that is submitted to BCI and stored at BCI prior to testing?
So when the evidence items are received by the laboratory, the seal is checked on those items of evidence, as well as when that item of evidence is retrieved for analysis, the seal is also checked and noted. If any irregularities would be noticed, that would be put in the analysis notes.
Okay, thank you. And I believe that I have used the phrase DNA, and I'm sure everybody has heard from TVs and movies about DNA, but could you please educate ladies and gentlemen of the jury here as to what DNA is and what does DNA stand for?
Yes, DNA stands for deoxyribonucleic acid. It is a blueprint for our bodies, so it's going to tell us things like what color hair we might have or what color eyes we might have. We get half of our DNA from our mom and half from our dad, and it's unique to each individual, except for in the case of identical twins, and it's also the same throughout our body. So if I were to take a swab from my cheek and a blood sample for myself, the DNA profile developed from each of those would be the same.
Okay. Now, in regards to DNA and what it is you just testified about, can DNA be used for comparison purposes to see if you can identify samples left behind on different objects to a certain individual?
Yes, it can.
Okay, if you would explain, ladies and gentlemen of the jury, how it is that you can do that.
So when we're making a DNA comparison, it's a 4-step process. The first step is going to be extraction. So we're going to take the DNA off of whatever item it was, whether it was a swab similar to a Q-tip, a cutting from an item, or a sample from like a cigarette butt. The second step that we're going to do then is quantification. We're going to determine how much DNA was obtained from that sample. Third step is called amplification, where we're going to make millions and millions of copies of certain regions of the DNA. And the fourth step is a real fancy word for taking a picture. It's called electrophoresis. So when I have those pictures at the end from both the evidence samples as well as the known reference standards, I can compare those two together and see if they are similar or dissimilar.
Okay. Now, in regards to DNA that may be left behind on a particular item, can you explain to ladies and gentlemen of the jury how that might happen?
Yes, DNA can be left behind on an item a number of different ways through bodily fluids, so saliva, urine, feces, semen, blood, or it could be left behind on an item by touching it. So my DNA would be expected to be on the binder that I brought with me today.
Okay. And if I use the phrase primary transfer, what does that mean to you?
That is the direct transfer of DNA to an item. So my DNA to my binder would be primary transfer.
And then what about secondary transfer?
Secondary transfer would be if someone came and picked up my binder other than myself. And if I were to try to swab their hands, they may or may not have my DNA on their hands because of that secondary transfer.
Now, in regards to internal lab protocols at BCI, what efforts are made to prevent cross-contamination or mixture of substances or samples that you may test?
So there are a number of different precautions that we take at the laboratory. Just to name a few, only one item of evidence is open at a time, so we're only looking at one item of evidence. We will also use a bleach solution to bleach down our worktops. We use brown paper to serve as a barrier between that bleached benchtop and the item of evidence. We also wear personal protective equipment, so gloves, masks, lab coats, just to name a few things.
So in essence, you're not going to be testing multiple items at a time, is that correct?
That's correct.
And I assume every time an item is tested, all surfaces and utensils will be cleaned before testing another sample?
Yes, absolutely.
And I assume that those are the protocols that BCI puts in place specifically for all employees to follow to make sure there isn't any sort of cross-contamination or anything like that.
Yes.
All right, so now in regards to DNA, what is the methodology that is used for determining if a particular item does have any DNA on it? And if it does, take us through the process, and I think you talked about it a little bit, of extracting that DNA from that item.
Yes. So initially the item is received by a forensic biologist, and the forensic biologist is someone that's going to look at the item of evidence and collect any relevant samples. So they're going to look at potential bodily fluids, see if they can perform any testing to try to help determine what that bodily fluid might be. They'll collect samples from either bodily fluids or samples where someone might come into contact with an item. So shirts, maybe the way they wore it. So they'll swab the shoulder areas that come into contact with your skin. If it's something like a cigarette butt, they might take a cutting from the paper around the cigarette butt. And those samples are then placed into a tube and they are sent forward for the DNA analysis process. The DNA analysis process is that 4-step process that I mentioned earlier.
And go ahead with just the different names of the process.
Yes. So first is extraction, second is quantification, then amplification, and then electrophoresis, where we get a picture of the DNA profile at the end.
So what is it that you're actually doing to the sample that you have in order to extract the DNA?
We are applying certain chemicals to that sample to help remove the DNA off of whatever the substrate was that it was on, whether it was a swab or a piece of paper, and get it into the solution so that we can look at just the DNA itself.
All right, and we're going to get into this here probably very shortly, but with that process, with that process that you do with the items that they're going to be compared, there's probably two different phrases that we're going to talk about. So what is a known sample?
A known sample is a sample collected from an individual, so the origin is known. So we can use that DNA profile obtained from that item as a reference standard for comparison to any unknowns.
Okay. And then what's another sample?
An unknown sample is a DNA profile that is obtained from evidence items within the case.
Okay. Like the items have been submitted to you guys?
Yes.
So then in regards to known samples that BCI would receive and unknown samples that BCI would receive, would you be able to compare those known samples to unknown samples to see if there is a match?
Yes.
And I assume when you make that type of comparison, whether they're known samples or unknown samples, do you generate or author a report to document what your findings are?
Yes.
And I assume that those reports are generated in the ordinary course of business by BCI?
Yes.
And those labs would be, or those lab reports would be kept in the ordinary course of business at BCI?
Yes.
And would you have done that in this particular case?
Yes, I did.
Okay. And when you compare DNA samples or unknown samples to known samples, are you able to calculate a statistical frequency of a particular DNA profile?
Yes, we will calculate statistics on the evidence profile to show how rare or how common it is within the population.
Okay. And if I may approach the witness, Your Honor.
You may.
Be 239 and 240. Okay, I'll hand you what's been marked as State's Exhibits 239 and 240. What are State's Exhibits 239 and 240?
These are copies of the reports that I authored in this case.
Okay. The true, fair, and accurate. Exactly. Let me ask you this. Is that a copy of the report?
Yes.
Is that the true, fair, and accurate copy of the report that you would have generated?
Yes, it is.
Okay. And would that aid you in your testimony today?
Yes.
Okay. And we have several things to go through. All right. If I may push the witness, Your Honor. I'll have you identify what State's Exhibit 222 is, please.
State's Exhibit 222 is BCI item number 1, which is a DNA standard from Ms. Brewsaugh.
And I think that is the only one that has not been opened. And what is contained within State's Exhibit 222?
State's Exhibit 222 has a blood card from Ms. Brewsaugh.
And if I can ask you to open that second book as well. I'll take this from you. All right, so 222. Does that have a similar label that it is that you talked about before, item number 1?
Yes, it does.
And we have the unique laboratory number 22-19832.
Correct.
And does this card that is inside, does that have any markings that you're familiar with or that you recognize?
Yes, it does.
Okay, what are the markings that you recognize?
The markings on this item have the BCI lab number, our item number, and the individual's initials and date of the individual who took the samples, as well as what date the samples were taken.
And then State's Exhibit 223.
State's Exhibit 223 is BCI item number 2, which is a DNA standard from Mr. Madden.
And if you would take out what's inside, and I'll put them into it. I did ask for permission before that permission to publish
Yes.
223.
Yes, correct.
And on the screen to your left, again, do you recognize any of the numbers or markings on that?
Yes, this is the barcode for BCI item number 2 under BCI case number 22-19832.
And then what is contained within State's Exhibit 223?
There are 2 manila envelopes in here, and they have slots within them.
Okay. And I believe this particular one. Just would you mind taking that out, please? Do you recognize, are there any markings on that particular exhibit that you recognize?
Yes, on this exhibit, there are the same markings as before from the analyst who took the sample from this item.
Permission to publish, right?
Permission is granted.
Is that what we're looking at here on the screen?
Yes, it is.
Real quick, Crystal Pontiac is saying, getting 5 memberships. Thank you so very much. I truly appreciate it. Thank you very much for the memberships. And real quick, Jolly Jake Global for $5 says, Sean, your MiG 37 will be there in about a week. Well, thank you, Jake. I appreciate it. So, sorry, I just want to get those out of the way because I know we might be going. Is there a reason why they don't want to show the expert on the stand? The expert apparently has the right to say, I don't want to be identified. She had the court offered that as an option, so she's taking it, which I think is highly problematic still. Remember, the court said if you don't want to be on screen, you don't have to be, which I still think is absolutely wrong, should not be allowed. So. Now, guys, this is going through all the DNA stuff. Are you guys okay with watching all this, or do you want to get to the direct and then get to day 5? That show where boredom was assassinated. Oh. Skip. All right, well, we'll skip ahead a little bit here. She's wearing a paper bag on her head to protect herself. Well, so, anyways, here we go, guys.
Correct.
Yes.
Okay. And then explain the difference then between State's Exhibit 239 and 240.
State's Exhibit 239 would have included also items that were not examined, items that had DNA profiles that were developed that were not sufficient for comparison, and it also contained all of the bodily fluid testing within that report. Those are things that would not be carried forward.
Clyde is EP.
Okay. So 240 is kind of a summary, and the date for the State's Exhibit 240 is February 21st, 2024. So State's Exhibit 240 would essentially contain a summary of 239 with the addition of the findings in regards to the cigarette.
Yes.
I have one more. I have a question, Chairman.
Thank you. Cross-examination.
Good morning, Ms. Daly.
Good morning.
I have a few questions for you. I want to first, I know Mr. Burris went through everything with you, but I just want to kind of summarize if I can real quick with you. So you still have your report with you?
Yes.
So I want to start just to kind of go back over some of this, make sure I'm clear. So you analyzed the left-hand fingernail clippings of Rachelle, correct?
Yes.
And you were not able to make any conclusions of whether Toby Madden's DNA was within her left-hand fingernail clippings. Is that what you said?
He is not the major contributor, and I can't make any conclusions regarding the additional DNA that is on the item. So I can't include, exclude, or even call it conclusive.
Okay. And it's the same, is that the same for her right-hand fingernail clippings as well?
Yes.
You were given 2 knives, correct?
That's correct.
One of the knives, it looks like item 7, no blood on that knife at all. Am I reading that right?
The sample from the blade was tested for potential blood, and that was negative.
So did you get just a swab, or did you get the actual knife to look at?
We had the knife.
Okay. But one of the folding knife, no blood on, just to come back to that, right?
No blood on the blade.
Okay. And then the knife, your item 8 says knife, multi-tool. Is that what you stood in front of the jury with?
Yes.
There was no blood found on that, correct?
Yes, the samples that were tested for blood were the swabbing from the blade, the swabbing from the broken blade, as well as the interior knife from where the broken blade sits.
Right. My question was, there was no blood detected on any of that, correct?
There was no blood identified on the samples I mentioned.
Okay. But you did say that looks like item 8.4, there was some of Rachelle's DNA on the interior knife from broken blade. Am I reading that correctly?
Yes, the major DNA profile was consistent with Ms. Brewsaugh.
But what you found was not blood, or what kind of DNA was it?
The sample was negative when we did our presumptive test for blood. So as far as where that DNA came from, I can't conclusively say. It could have been from skin cells. It could have been from some other bodily fluid that wasn't tested.
Okay. That was what I wanted to know, because, and I'm probably not saying it right, but sometimes when we find DNA, it could be my blood, it could be my skin cells, it could be sweat, saliva. But item 8.4 that you tested doesn't have blood.
Correct. There was no blood identified.
So if there's any DNA of Rachelle that's some other form, like skin cells or whatever, that's other than blood, that's fair.
Yes, I can't say what though.
Right. Do you have any knowledge that this knife that was found was actually inside Rachelle's purse?
Yes, I did know that.
Okay. But you said it would be unusual to find DNA on that part of the knife, but you would agree with me it would be unusual if it's a knife that's in someone's purse that they may use almost every day, correct?
I would be more expectant to find her DNA on like the exterior of the knife, so when we swap the handle, I would expect to find her DNA there. This is kind of just an odd place to find DNA since it's really far deep down inside. You can't theoretically like even stick your finger down in there.
Right. Have you ever used the multi-purpose tool? Have you ever used one of those?
Rarely.
Well, when you saw it, you see that there's little slivers in the top of each blade where you almost have to put your fingernail on to pull the blade up. Did you see that?
Yes.
So you're saying it would be uncommon if I'm opening that up, using my fingernail, my skin cells to pull the blade up, that it would be uncommon for my skin cells to be within the knife?
Not necessarily like, I would expect your skin cells to be on that portion where you're contacting it and pulling it up. But this sample was taken from deep down in that groove.
Okay. Have you ever used a knife to clean your fingernail beds out?
Not a knife, no.
I understand, but not everybody does things the same way. Would you agree with me on that?
That's true, yes.
Could you, I know you're not going to do that, but could you use the end of a knife such as what you looked at just to kind of clean your nail beds?
You could.
Right. Also, with regards to, I think it was the right green shirt, you said that was positive for blood, but the steps weren't taken then to determine exactly whose blood that was. Is that fair?
Yes, that's correct.
Now, item 12 is a green jacket, and that's one of the pieces that you analyzed. And you said that Toby Madden was a minor DNA profile. Do you remember saying that?
Yes.
For item 12? Do we know what DNA that is that you found there? Is that skin cells? Is it sweat, saliva, blood? Do we know what that was?
The sample that was collected was presumptive positive for blood. I can't say whether his DNA profile was as a result of his skin cells being deposited on that item or if it was also his blood.
This is the expert from the Bureau of Criminal Investigation. She's the DNA expert. You heard her talking about all the DNA testing. This is the forensic lab expert from the Bureau of Criminal Investigation. It's the state crime lab. So they went through all the evidence, all the blood that they found, and how they tested all of it.
And the clothes you have on today, the clothes I have on, every time I touch my coat here, touch my tie, I'm depositing DNA and cells all over my clothing, correct?
That's correct.
So it's not unusual for a piece of clothing to have someone's own DNA on it, right?
Correct.
Yeah, he likely wiped it off with peroxide.
Just a minute.
Sure.
No further questions.
Okay, redirect.
I just have one redirect question. There was some of the DNA that you tested that you were not able to make any conclusions as to whose DNA it is, correct?
That's correct.
And why would that be?
It could be for a couple of reasons. The amount of DNA that was recovered from that item doesn't give a reliable enough DNA profile, so it doesn't meet our standards for comparison. It could have also been the quality of that DNA profile doesn't lend itself for comparison, or there could have been a number of individuals contributing to that DNA profile, making it also not sufficient for comparison.
Thank you. What else, Sean?
No recross.
Yeah, I'm gonna sit down. Thank you.
Council Brooks.
Sure.
All right, chat. Hold on here.
Conversations and my conversations with this witness, she does not wish to be recorded. I'm sorry, video.
Right. You left something on the project.
There's another witness that doesn't get it recorded. This is nonsense. Oh, I hate this.
Proceed.
Good morning, ma'am. I appreciate you being here. Would you please state your name for the record and spell your first and last name?
Tanya Cook, Tonrin.
Okay. Do you know an individual by the name of Rachelle Brewsaugh?
Yes,
How do you know Rachelle Brewsaugh?
we were friends.
How long have you known Rachelle Brewsaugh?
We were when we were younger, and then we played ball against each other, and then as we got older, because of Toby.
Okay. Are you all nervous being here?
Yeah.
Okay.
We need that microphone.
Yes.
for the witness.
Average.
Yes, thank you.
Having some difficulty hearing this. So.
Okay.
Let me, if I can ask that last question again. How's it that you know Rachelle Brewsaugh?
We were friends. We
Okay.
were friends.
How long have you guys been friends?
When we were younger, we played ball against each other, and then probably 5 years
Okay.
as adults.
And do you know an individual by the name of Toby Madden?
Yes,
You see Toby Madden in court today.
yes.
Would you please point to him and describe for ladies and gentlemen of the jury what it is he's wearing?
A blue dress shirt,
Okay.
the stripes.
No, that's a record to reflect the witness has identified the defendant Toby Madden.
The record will so reflect.
And ma'am, I want to direct your attention back to around Christmas time of 2021. Did you have contact with Toby Madden around that time?
Yes,
Did you hear him say anything about Rachelle Brewsaugh?
yes.
What did he say about Rachelle Brewsaugh?
Objection.
Little,
You can answer him.
he said that he would cut her head off, put it in her mom's lap, so the whole family would have to suffer.
Wow.
Judge.
Cross-examination?
Wait, Pete Rose died? Oh, shit. Guys, Pete Rose died. Damn. That's no bueno. Guess you never get in the Baseball Hall of Fame after all.
Ms. Cook, that was pretty quick. Are you Toby's cousin?
Yes,
What makes you think that?
our grandmas are sisters.
What grandma, what's her name? Let's see.
My grandma Venerable and his grandma, they were Molly and Polly Venerable.
Yeah.
Or Crowther or something, I don't know the last name.
Did you get involved in this case where someone reached out to you, or did you call down the police department?
I called them.
This statement that you just say you heard, you said he was going to cut off her head and put it in his mother's lap?
Not his mother's, her mother's. That's before she passed away.
Okay. Who was around when he said that?
My daughter, my husband.
Who's-
He said it over and over again. It wasn't just one time. It was over and over again.
When you say over and over again, you talking about this that day?
No, just different days.
So I'm assuming you called the police, right?
When he said that?
Yeah.
No, I did not.
You said he said this in the presence of your daughter. What is her name?
Haley Cook.
And you said it was in the presence of your husband?
Yes.
What's his name?
Krista Warren Cook
Where were you at when this was said?
at my house.
What were you guys doing?
Toby would sell clothes and shoes, and
Were you selling clothes and shoes inside your house?
he would bring them in his truck, and I would buy shoes from him or clothes, whatever.
Okay, so when I asked you what you were doing that day when he said this, you're buying clothes and shoes from him?
Yeah, it's depending on what day it was. Like,
Well, I'm
like I
asking-
said, he has
I'm
said
asking
it
you about
over
the
and
day
over
that he made
again.
the statement. What were you doing that day that he made this statement?
I don't know. We were maybe sitting on the couch. I don't know exactly. We were talking, sitting there.
You know what day it was?
No,
Day of the week?
no, because he said it quite frequent. It was either he was going to stab her to death or cut her head off and put it in her mom's lap.
Where was he at inside your
Why
house? when
can't
he
he?
said this?
You're allowed to do that.
It would be like right next to me on the couch.
All right, so he was inside your house.
Yes,
And your husband was there?
yes.
Were you drinking that
I
day?
don't drink or do drugs.
Your husband does though, right?
Yes.
Was he drinking or using drugs that day?
I don't know.
Well, how long have you been married to him?
22 years.
You can't tell us whether or not your husband's drunk after 22 years of being with him or on drugs?
He possibly was on drugs that day.
Did you ever take Toby to the hospital to see Rochelle's mom?
No,
Never?
never,
Did you ever take Toby anywhere to go see Rochelle's mother?
never.
Did you ever see Toby around her mother? Were you able to observe the two of them together?
No.
Did you ever see at your house Rochelle hit Toby with a stick?
What, it was a thing that you put up underneath the doorknob to keep people from coming in. He had come to the house. Rachelle was there, and I could tell by his knock that it was him. I was like, "That's Toby, Rachelle." And so she got up and answered the door, and he had the stick, and he hit her with it.
Oh, he hit her?
Yep.
Did she ever hit him with it?
She took it back she got it from him and hit him with it.
The
Also.
stick was put up, exhibit 66, please.
I'm sorry.
I'm sorry, say exhibit 66.
Sorry.
If you would mind. Since you're connected, my computer.
I just thought it was-
Can you see, is there a screen in front of you that has that name?
Yeah.
Does that look like the stick that Rachelle was hit Toby with?
No,
It doesn't?
no, it would have actually, it was like silver.
What color is this object?
I can't tell the color of that. That's not it.
You said this thing, whatever this, that Rachelle used to hit Toby, was it metal?
Yes,
And you said it went under a door?
it was to help secure your door in your house. You stick it underneath your door. But Toby was the one that came and hit her with it first.
Right, but you're not denying that she then grabbed it and hit him, correct?
No, I'm not denying that. She did.
That really hot, cold relationship, didn't they?
Well, I mean, she was defending herself.
Was that a yes or no? Did they
Hot
have a
and cold
cold
relationship? Yeah, she was trying to get away from him, so it wouldn't be hot and cold anymore.
I understand that, and I'm not trying to disrespect that she's passed. I'm going about what you saw between these two, because the reality is, on the day that she was stabbed, you don't know what happened inside
No, I
the
do
house,
not.
do you?
No, I
But you do know that they have a rocky relationship, don't you?
Yes,
And you do know that she hit him with the stick, whether he used it first or she used it first. You see her hit him with the stick.
Yeah.
That goes under a door.
yes.
Did you ever go as far as to tell the police that Toby pulled a gun on her?
No, I did not.
You didn't do that? Just 9 seconds.
Sure.
No further questions.
Anything else?
There you are. Thank you.
Okay, maybe they sat down. Thank you.
And also,
Yes, please.
on behalf of the state of Ohio, I believe this one is really mistakes.
Very well.
All right, so the state is finished, guys. And we're going to see where we're at. Notice they only give him the golf course pencils. He doesn't get real pencils.
Okay, ladies and gentlemen, it's the court's understanding that the state has presented its last witness to you. So at this time, we need to take care of some business outside of your hearing. So I'm going to go ahead and release you a little bit early today so that we can take care of that. We'll come back at 9 o'clock tomorrow morning and proceed from there, okay? But please remember my recess instructions.
Case exhibits 1 through I think 1 through 206. They're all already.
That's a lot of freaking exhibits for a simple murder, chat. 206 exhibits. It's a lot.
And that's what my recollection is as well. However, there is no exhibit 177, is that correct?
Correct.
Okay, so that takes us to 207 and we'll go from there.
So, Your Honor, I believe the coroner's report is self-authenticated, documented, is certified. I think it comes in that way without any testimony.
Any objection?
Hold on one second.
Okay.
I'll just catch
Sure.
make sure it doesn't have. Yeah, you're talking about 207?
Yes.
Yeah, that's fine.
Okay, so that'll be admitted. And then I have 208, 209, 210, and 211 being admitted, 212 being identified but not admitted. That is the wallet.
I am asking for its admission and or photographs one way or the other. I know it's a wallet. I think there's under driver's license and stuff like that. So whatever the court's preference is, I'm just.
You said are there photos of it?
So we could either
Oh,
introduce that as an exhibit or we can take photos of it. It's going to be 212.
Just your ID probably expired. Yeah. You can send a wallet back. I was just making sure there's.
There's also some dollar bills as well. A couple of those.
No, it's fine. That can go back.
All right, so was it that?
For like social security stuff, not the.
All right.
We'll do that. It should be.
So we're going to skip ahead here, guys. Knock out all this garbage.
Okay, 223, 20 being identified or admitted.
Correct. There's no.
You got a 236.
Yes.
Any other evidence?
The state has no other witnesses to present, no other evidence to submit
Okay, so we'll find out what the defense is going to do here. Let's take a look.
and state arrest.
Very well. Of course, we'll let you do that in front of the jury tomorrow.
Yes, sir.
Okay, now that the state has rested, Mr. Wilder, is there anything you'd like to put on the record?
Judge, this time we would make a Rule 29 motion for acquittal all charges. I just argue that the state, even construing evidence in the light most favorable to them, if not provided sufficient evidence on all the elements of all the charges presented. Thank you, Judge Honor.
Anything that the state wishes to put on the
I
record?
believe we put sufficient evidence forward to want the case to go to the trial fact.
All right, well, the court has carefully listened to the evidence and considering Rule 29 and the appropriate standard in that rule, the court is going to respectfully deny the motion. Okay, anything else that anyone would like to take up today before I take up a few items?
Nick,
Not at this time, Judge. Obviously, I'm discussing with Mr. Madden, his case and whether he's going to testify or not. Once that decision is made, that'll obviously be something that I'm not sure what this county does or you yourself, Your Honor, but that may have to go on the record.
Very well.
But nothing other than that.
All right, well, that brings me to the jury instructions that I wanted to discuss with you. And in those instructions, we have started out by saying that Mr. Madden would not testify, but certainly we will amend that if in fact he chooses to exercise his right to testify. So I'll have that language prepared to go either way based upon what happens with the case as we proceed. Other than that, Mr. Burris, Mr. Hahn, do either of you have any comments, corrections, or requests to the draft jury instructions that I have provided?
I don't believe so at this time, Your Honor. We don't know.
Sure, and I understand we probably have to conference again, but I just want to have them in the best position possible so that they're easy for us to modify and alter as we proceed. Did you have anything that you wanted to change or add, Mr. Wilder?
Judge, I don't see anything with what's printed out here. However, based on some of the testimony, there is potential that we may be requesting an instruction on voluntary manslaughter. I will certainly find something as a formal record, but other than what was printed out, I don't see anything in there at this point. But if anything additional like that instruction requested, I will certainly file something and obviously bring it to the court's attention.
All right. Well, then I will leave them unchanged at this point, and if the defense chooses to present a case after that, we'll conference again and see if we need to make any other changes.
All right, thank you.
Okay. Anything else
That is not appropriate, sir. Not appropriate at all.
before we recess for the day?
I assume it'll be the court's intention to try to get this, this case to the jury by sometime tomorrow, this day's latest witness day.
If we are still presenting evidence or doing closing arguments, or if we're not finished with those things, I would anticipate asking the jurors if they would like to stay or not. If we're in deliberations, likewise, I will ask them if they wish to stay.
All right, let's see if they're fighting or arguing. Notice the camera's focused on them, like getting ready. What are they doing? So, all right. So we're going to move on to day 5, chat. We're going to back out of here, go to day 5.
Focus. My mom always.
All right.
That's more soon in the process. Okay, so we'll be ready for closing arguments, and we talked about our jury.
My understanding that my client does not want that done, so I want to put that on the record.
Very well.
Does not want that to occur.
Your Honor, and hopefully so taken.
Anything on behalf of the defense at this time?
Yes, Judge. This morning, we had a couple witnesses who were going to testify. One of them is Mr. Madden's brother, Tim, who's in the courtroom today. I plan to call him, but it's my understanding that my client does not want that done, so I want to put that on the record.
Very
Does
well.
not want that to occur.
All right, very well.
Okay, so he was going to call in some witnesses, and Toby Madden didn't want to do it. Interesting. Also, Dust Boot, no, they don't go to the animal shelter to feed people. So, yes, the trial ended Friday, and we've got it. We've got day 5 right here. So, day 5 is on Friday. Also, look, Clyde is still so sleepy. Look at him. He's got his tongue all sticking out, and he just bleh. Him. Let's get back to this. So, why no witnesses? Because he didn't want to call any. Remember, the defense doesn't have to produce any evidence. They don't have to produce any evidence. So, remember, it's not his obligation. It sounds like he wanted to bring out some good character evidence, but that's gone. And they're resting, and the prosecutor's already rested. So, he's just putting it on the record. I wanted to present stuff. He didn't want me to do it. Therefore, I'm not going to do it. Does he snore? Yes, he snores like an adult. He snores like a human being.
Anything else you'd like to put on the record today?
We also had a neighbor, Tamara Dewar. She was here Monday and Thursday. I thought she was going to be back here today to testify. She does not appear to be here at this point. However, given some of the testimony by other neighbors and the reason she was going to be called, I think we have got into evidence. So I'm not requesting that her appearance be found at this time.
We will be letting the state of Ohio rest, and would you like to present a case after the state is rested?
Your Honor, with those things that I just mentioned, the only other potential witness would have been Mr. Madden himself. So I don't know if this is the time to discuss that or not, because his decision whether to testify or not. So given that he doesn't want his brother and there's no other witnesses ready and available, Mr. Madden is the only remaining one. So I think we need that colloquy now.
Mr. Madden, you do have the right to testify in this trial. It is your constitutional right. Do you wish to exercise that right today?
No.
All right, then we let the state rest its case, and we will be prepared for closing arguments. Let's go ahead and take a seat, because I think we're going to have some other business then to take up, so we can move on. That's more smoothly process. Okay, so we'll be ready for closing arguments, and we talked about our jury instructions. I did see that you filed a proposed jury instruction. Mr. Wilder, I have reviewed your motion. Is there anything else you'd like to put on the record in support of your request?
No, Judge, everything I would say right now is contained within my motion. It's filed as record, so I can stand on the motion and incorporate those arguments in paper as if stated here this morning. So I will stand on my motion.
And does the state wish to respond to the request for the jury instruction?
So, Your Honor, voluntary manslaughter, I read as being defined as no person while under the influence of sudden passion.
So they're trying to argue for a lesser included offense this year, chat. Trying to argue for involuntary manslaughter. Involuntary manslaughter would be a 3 to 11-year sentence, which would be a lot better than the 15 to life that he's facing. So it's worth going for it.
Or in the sudden fit of rage, either of which is brought on by serious provocation occasioned by the victim, that is reasonably sufficient to excite the person into using deadly force, shall knowingly cause the death of another for the unlawful termination of another's pregnancy. Obviously, that word doesn't apply. Well, I certainly will probably go find some arguments that stabbing somebody 55 times certainly seems to be a sudden fit of rage or sudden passion. I do not believe that there's any evidence that would suggest, or any evidence that was heard from this witness stand that says that was brought on by the victim of Rachelle Brewsaugh. So at this point, because that part is lacking, I would object to the instruction.
Okay, well, the court has reviewed the statute as well as State versus Amison, which is a 12th District Court of Appeals case 2021, Ohio 1537. And in that case, the trial court declined to give an instruction on the voluntary manslaughter in a murder case, and the 12th District Court of Appeals upheld the trial court's decision. The court referenced State versus Gray, also out of the 12th District, 2011, Ohio 666 in its decision, and indicated that for provocation to be sufficient, it must be sufficient to arouse the passions of an ordinary person beyond the power of his or her control. And I quote from the Gray case that was referenced in Amison: if insufficient evidence of provocation is presented so that no reasonable jury would decide that an actor was reasonably provoked by the victim, the trial judge must, as a matter of law, refuse to give a voluntary manslaughter instruction. And the court has carefully reviewed the evidence that the defendant believes was proper that would support the instruction. However, in this court's mind, the court does not believe there is sufficient evidence for it to give voluntary manslaughter instruction. So it is respectfully going to deny that request. Anything else with the jury instructions that we have gone over that the court proposed previously?
I think all of them are standard, issued a jail instruction. I would just ask for a new copy of what it is. It's also can be read.
Any other requests for additions, Mr. Wilder?
Other than what we requested, I understand the court's ruling. I didn't have any other issue with the instructions as given to me.
Okay. All right. I'm going to use the same copy that I gave to you, but we will be printing them out for the jurors. If we make corrections during the course of that, I'll print up a new copy and make sure everybody has those before they go back to the jury.
I do see. Your Honor, when I read through the draft, I think the pronouns were wrong. In some of the parts, I think it said her, it should say him.
Okay, I will hopefully catch those as I read them and make the changes for the final copy that I'll provide to you and before it goes back to the jury.
Judge, if I may, I did know that Mr. Madden's decision, he just put on the record to not testify. Obviously, the language of him not testifying needs to be in the instruction.
That is.
Oh, because we have it in
It
this
says
way.
the
Yes,
fifth
sir.
testify, so obviously there needs to be language about him not testifying and accepting the standard language.
Yes, sir.
Not to use that against, so.
Thank you for that.
Your Honor, if I can just get one more thing. I've asked him multiple times to.
Oh, he's going to talk. He's going to talk, chat. Let's slow it down.
To subpoena some information that would show how this all started, and he's refused over a period of months. He's told me to my face that it's not going to subpoena the information, and that if I try, he said later on, you're just going to have to file an appeal. But I'm not, for the same reason that the neighbor that was next door to us, the mayor, the one who robbed the bank, there was on record, that she was saying that me and Rachelle both were great neighbors, and I don't look like somebody that would be a murderer. And, she was happy to have us, and she let me use the phone all these different times to call while we still were living. But he thought that wasn't sufficient enough evidence for the jury to hear. And I thought it was. He said, but if you try to bring that forth, I'm going to make sure that she shuts it down. Why would he have you shut that down? I don't understand. But listen, you've made a ruling. There's plenty of things that I thought that needed to come out. For example, when I asked him to ask the detective this summer right here, when he ran down the hallway after I was beat up on March the 27th and taken down 2 hallways, dragged out of my shoes down to the bottom of the basement inside a cell, you can hear me screaming out. Why did he leave this courtroom and run down 2 hallways? Why did he come up to my face? What did he say to me? What? He goes, I don't. And then, when I said, hey, ask him if he knows Rachelle's niece who works at the front desk at the Hamilton Police Department. in the same building that he works at. I just asked him if you know how well he knows him. He refused to do that. So there's so many things that I thought that I just wanted to put on the record. And that's all I had to say.
I don't know what he thinks he's going
Is there
to
anything else, Mr. Wilder?
Judge,
ultimately.
I'm not going to respond to the allegations because if I were to do that, I would be breaking attorney-client privilege, and I'm not going to do that at this point. I'm prepared to argue this case as best I can based on the limited discussion we've had about the case. Despite my many efforts and meetings with him, not having a lot of information about the situation that occurred has limited me, but I'll just leave it at that.
Well, but one other thing. You know that on March 27th, about near 9 a.m. 2024, I was brought in here in the afternoon, probably sometime. Most of the time I had hearings that were in the afternoon, 3:15, 1:45. Times that my family didn't even know that because times were being logged on the computer when I was having court. So nobody could be here. I was brought up with no other inmates. I was always and woken up out of my sleep, said, hey, you got a court date today. Having hearings without me there. But I was in the jury box and I said, hey, they wanted to have a proceeding with me while I was inside there. And I said, I protested. I said, hey, listen, I'd like to be at the desk, so that I could go on record. Because if at any time that there's been a proceeding or a hearing here, if you haven't heard my voice, then you can sure be 100% know for a fact that I wasn't there. And being that I was not allowed to come over and sat at the desk, listen, and I protested. I didn't want him as an attorney. You know that I didn't want him as an attorney. And I told you all that. I don't want him as an attorney. And for that reason, he said, get him. And I had his shoes beaten off of me all the way down the hallway, down 2 hallways, down to the elevator. And this man right here gets up for some reason and comes down the hallway.
I'm going to stop you, Mr. Madden.
And ask him what he said to him.
We've talked about some of this before.
Okay.
Your jury is waiting, and I don't want to keep them waiting, okay?
Yes, ma'am.
So if
Yes, ma'am.
if everybody's prepared to go forward, we'll go on with the closing
Yes, ma'am.
arguments, and I'll have the jury instructions modified while we're doing that and have them passed out to you before they're read to the jurors. But we will
But I
change
did
the
ask
language
for
of that.
on the record, I did ask for that preservation of that footage, of the footage when I was going to jail too. So, but none of those things, no, but here we are.
And we're going to go ahead and bring in the jurors, okay? Thank you.
All right, guys. So yeah, there you go. That's Toby's acting like a fucking loon. He wanted me to subpoena information. What was that information? What would I have really done? I doubt much. Yes, I've dealt with a lot of clients this is difficult. That's not rare.
Good morning, ladies and gentlemen.
That's not rare.
Does anyone have any violations of the court's recess instructions to report?
That's not rare at all.
All right, we left off with the last witness being presented by the state of Ohio. How does the state of Ohio wish to proceed this morning?
Yes, Your Honor, at this point, with the admission of all the state's exhibits, there's no other witnesses to present. So, ladies and gentlemen, the jury can say the rest.
Very well. And Mr. Wilder, does the defendant wish to present a case?
No, Your Honor. Thank you.
Very well. Okay, so ladies and gentlemen, you have now heard all of the witnesses and you will receive all of the exhibits into evidence, and it's time for closing arguments. So please keep in mind that the closing arguments are not evidence. They are designed to assist you, and they are the attorney's views of how they think the evidence proves or does not prove the charges. So they are designed to assist you, but they are not evidence. Now, in accordance with the rules, because the state of Ohio has the burden of proof, the prosecution will go first with its closing argument, and after they have concluded, the defense will have the opportunity to present its closing argument, and then because of that burden of proof, the prosecution has the burden to give you final words and a rebuttal closing argument. So that is how we will proceed with this portion of the trial, and whenever the state is prepared to go forward, you may do so.
Yeah. Good.
Sure.
Yeah. Morning, ladies and gentlemen. Back over there. I'm going to read to you Toby Madden's own words. These are the words that he spoke on Monday before you entered the courtroom, before opening statements. I'm responsible for what happened to her. I didn't mean it. I'm so sorry. I love you. Please don't hate me. Can you put up State's Exhibit 181, please? This is what he's responsible for. Can you put up State's Exhibit 40? 55 times. He didn't mean it. Let me take that down.
That's That's powerful. 55 times I didn't mean it. That's pretty good.
If you recall from my opening statement on Monday morning, I told you how every trial is like a puzzle and that you receive pieces of the puzzle throughout the week. And that's what's happened this week. And you receive those pieces of the puzzle from the exhibits that have been admitted and from the witnesses that have testified. And I want to talk about those pieces that you've received all week long. I want to help put them together for you. So we know, and I'm not going to go in the same order that they came in, but I'm going to try and put this in chronological order for you. So we know from Rachelle Madden and Tanya Cook that the defendant and Rachelle were together for about 25 years, or north of 25 years. That they moved around from place to place. Michaela said they moved around from place to place, and they finally moved to 1270 Parish Avenue in the city of Hamilton, Butler County, Ohio, in early of October of 2022, and that they were renovating this home and fixing it up to live there. We also know from Michaela that they had a rocky and on-again, off-again relationship. And we know from Tanya that the defendant had been seen hitting Rachelle in the past, and that he said that he wanted to cut her head off and put it in her mom's lap. And he said it multiple times. I'm not sure that rocky is the right word for that relationship. We also know from Detective Horton that on October 10th of 2022, the defendant went to the Kroger on Route 4 in Grand Boulevard here in the city of Hamilton. And that was in the evening. And you saw the video and the still photos. He had on a gray shirt, short sleeve shirt, button down shirt, a green vest, white shorts, and Nike Kevin Durant 8 shoes, or KD8s. And that was in the late evening around, I believe it was around 8 p.m. on October 10th. And the next pieces that you got were from the city of Hamilton utility workers. You heard from the 4 of them, specifically the 3 that went into the house. We know that there was an appointment that they had at 8 a.m. on October 11th in the morning, that they showed up on time, that Rachelle let them in, and then she sat on the couch, had a hold of their large, big dog. I believe one of them said it looked like a pit bull. All the furniture was in its place. The china cabinet was upright. The entertainment center was upright. There weren't any chairs overturned. Nothing was overturned. And that they walked through the house and they saw a male sleeping in a chair in the adjacent room. They went into the basement. They did whatever it is they were doing, running their test on the gas line, and they determined that they can't turn on the gas because the furnace is broken or it hasn't been fixed yet. And they go back upstairs, and they're leaving at about 8:25. They see the male still in the chair. I think he acknowledges a "what's up" to one of them. They tell Rachelle that they can't hook up the gas because the furnace isn't working. And that one utility worker told you that she then looks to her right to the adjacent room and gets a stare or a look to the male in the chair. And then when they left there around 8:25 in the morning, she was alive, she was well, still had a hold of her dog, everything was fine in that house. And we know from Ann Mayers, who testified, that as she did every day, as she said, she was on her porch at around 8:45 a.m. because she watches her sister's grandson with her sister walk to school at Crawford Woods Elementary, which is right down the street. After the grandson gets around the corner and heads up to the school and out of eyesight, her sister goes inside because she said her sister wasn't feeling well. So Ann sat out there, still drinking her coffee, looking at her phone. Then she tells you that sometime between 9 a.m. and 10 a.m., roughly, she doesn't remember exactly, it was 2 years ago, that she hears a scream. You all heard it. She did it for you right here in the courtroom. And she said it lasted 5 to 7 seconds, and then it came from her left. She's at 1260 Parish Avenue. They're at 1270 Parish Avenue on her left. But as she said, she doesn't know. There's a lot of kids in the neighborhood. There's a lot of screaming that goes on, but she heard this one from that direction, but she didn't do anything about it. She didn't call the police. Said she went inside and she ate breakfast. And from that time that she was out on her porch, she said there was no one else out there at 1270. She didn't see anyone. The utility workers had already left. And then the next thing we know is that Officer Katie Johnson arrives there around noon or 12:10 in response to a 911 call. She gets there. The defendant's inside giving CPR to a clearly deceased body. There's multiple stab wounds in the body. Officer Johnson saw that. She said the body was very pale and the intestines were protruding from the torso. She pulls the defendant off of Rachelle and takes him outside. At this point, he's got on a lime green shirt, shorts, and Reebok shoes. Officer Johnson told you at that time there is no signs of forced entry in that house. So when you look at the timing from when Ms. Mayers told you that she heard that scream, and by the time Officer Johnson gets there, the defendant had roughly 2 hours to be alone in that house with Rachelle. And you heard from numerous detectives about the scene and their investigation and the pieces of the puzzle that they give you. When they get there, there's no forced entry. Front door, jamb, is fine. The back door, it does have a dent in the door, but it's got 2 deadbolts. You saw the picture of that. That door's locked, it's secure. Rachelle's lying dead in that front room with multiple stab wounds in her body. That front room is in disarray. Furniture's overturned. You saw the cabinet on the floor right next to her. There's blood everywhere, on the walls, on the floor. It smells like rubbing alcohol, and there's 2 empty bottles of rubbing alcohol in that room near her. And then in the basement, which is completely dark, if you remember, those detectives told you, there's no electricity down there. They had to light that up themselves. They find a green vest, a bloody green vest. Turns out there's the bloody gray shirt down there, which, yes, they didn't get that until about 15 days later because of the Kroger video. But they don't find any white shorts or any Nike KD8s. There's a wooden board on the ground next to Rachelle's body with 2 distinct shoe prints on it. One of which is that Reebok shoes that he was wearing when the police got there. And the other one, as Detective Horton told you, as he found on the internet, is a shoe print of a Nike KD8. There's blood in the bathroom sink and on the bathroom floor. And keep in mind, he had roughly 2 hours from the time Ann heard that scream to when the police got there. They find a Swiss Army knife in Rachelle's bag. And it appears to be wet when Detective Horton finds it. Detective Trenham tells you when he examines it, it appears to be rinsed or washed. And it's got a deformed blade, a broken blade, that matches and is similar to the tears in the fabric in the green vest and the cuts in that Planet Fitness shirt that Rachelle was wearing. And you know from Detective Horton that the defendant told him, you got to find those 3 city guys. You got to find them. There's people out to get me. There's not anybody that I know that wants to hurt Rachelle. And then Catherine Daly from BCI supplies you with these pieces. Rachelle's blood is on Toby Madden's green vest. Rachelle's blood is on Toby Madden's gray shirt. Rachelle's blood is in that bathroom sink. And Rachelle's DNA is down in the well of that Swiss Army knife. Down in a part where, as she said, you're not going to stick your finger down in there. It's not going to fit. And we know from Dr. Up the Grove that Rachelle died from 55 stab wounds. They were on her arms, they were on her leg, they were on her torso, they were on her head, and one in the back. And he told you there were defensive wounds on her hands and her arms, the bruising on her hands. He also told you there was a small knife that was used. And he told you that when you look at those pictures, the darker wounds are because the blood was still pumping, her heart was still pumping. And those lighter wounds, they came as the life was slipping away out of her. You put these pieces together, and I submit to you that this is what you get. You got 3 City of Hamilton utility workers that leave that house and everything's fine. Something happens at this point. It's a piece we don't have because the only 2 in that house are the defendant and Rachelle. Maybe she says something to him about the furnace. We don't know. But he goes off. And ladies and gentlemen, there's 1 stab wound in the back. And I submit to you that that's the first one. He attacks her from behind. He stabs her in the back with a Swiss Army knife. She turns and she tries to defend herself. And this is where the defensive wounds come in. And he keeps stabbing her over and over and over 55 times. And in this process, they're knocking over the furniture. She's trying to get away from him. She's trying to live. She's trying to survive. But she doesn't. And then he changes his clothes. He throws that vest and that gray shirt in a completely dark basement, hoping that no one will find it. He ditches those white shorts and those KDA shoes. Don't know where. Can't find them. He had 2 hours to do it. Then he tries to clean up. He's putting that rubbing alcohol everywhere in that front room. Detective Huckey told you, distinct smell. Then he goes in the bathroom and tries to clean himself up. That blood's everywhere in the sink. Her blood that he's washing off of him, washing off of his own hands, washing off of his own arms. And then he tries to clean up that knife. He tries to get her blood off of that knife. And then after he does all of that, he has the audacity to start giving her CPR when the police arrive and try to blame it on 3 City of Hamilton utility workers. And the final piece of that puzzle is what the defendant gave you here on Monday morning that I've already told you. I'm responsible for what happened to her. He said it to his daughter, sitting in the back of the courtroom. Ladies and gentlemen, you're going to have 4 counts here to consider when you go back to deliberate. And the judge is going to instruct you on the law and what some of the terms are in those counts, what they're defined as. And I'm going to give you a shorter version of that here now. Turn the thing. So I'm going to take these in reverse order. So I'm going to start with count 4 because I think it's a more logical way to look at these. Oh my gosh, how do I I'm sorry, give me 1 second. I think I got it. Count 4, felonious assault. Knowingly cause or attempt to cause physical harm to Rachelle Brewsaugh by means of a deadly weapon, in this case a knife, and then it occurred on October 11th, 2022 in the city of Hamilton, Butler County, Ohio. The judge is going to instruct you that knowingly means a person acts knowingly regardless of their purpose when the person is aware that their conduct will probably cause a certain result or probably be of a certain nature. When you stab somebody 55 times, it's pretty clear that that conduct is probably going to have a certain result or be of a certain nature. I don't think there's any disputing that. And in this case, he used a knife. I submit to you, it's that Swiss Army knife. And clearly, as we've stated over and over, and you've heard, this happened on October 11th, 2022 at 1270 Parish, the city of Hamilton, Butler County, Ohio. Count 3, felonious assault again, serious physical harm. I just read to you before what knowingly means. It's the same argument. Cause serious physical harm to Rachelle Brewsaugh. Ladies and gentlemen, there is nothing more serious than death. That is the worst kind of serious physical harm. And again, October 11th, 2022. Count 2, murder. Cause the death of Rachelle Brewsaugh as a proximate result of committing the offense of felonious assault. We just went through those felonious assault counts. 55 stabs. She's killed. She's laying dead in that floor in the front room of 1270 Parish. Count 1, murder. Purposely caused the death of Rachelle Brewsaugh, again on October 11th, 2022. The judge is going to tell you that a person acts purposely when it's his specific intention to cause a certain result. Ladies and gentlemen, there is no other result that can be intended from stabbing someone 55 times. There's no mistaking that. Clearly, it killed her. It hit her internal organs. It hit her liver. Here's her heart. Here's her lungs. That's a certain result. You know what you're doing. So you've sat here a week and listened to all of this. You've received all the pieces of that puzzle. You put them together. It's very clear. That puzzle is the defendant, Toby Madden. Find him guilty on all 4 counts. Thank you.
Thank you, Mr. Hahn. Mr. Wilder?
Wow, guys, that is a thorough and quick. Think about that. Thorough and quick closing argument. If they were all like that, Salty says the fact he's not doing it now is proof that he didn't mean it. He should have done it. Yeah, that's not going to get you anywhere though, because the court will say he didn't do it. Therefore, what more do you want? If I get what you're saying, but that wouldn't work out that way. Just something to think about. But think of how quick that was. Even at, the speed, it was short. It was good.
The first thing I want to do is thank you. We've taken 5 days away from you. Some of you may be happy that you're away from work, but we've taken you away for 5 days to consider this case. And as we can all agree, couldn't get much more serious with allegations than what we've been here all week for. Don't think that it doesn't go unnoticed that we don't see you paying attention, listening to the witnesses. Didn't appear that anyone fell asleep. We appreciate that you did that because a serious case involves serious jurors, and you're up to the task. Before I start with making my comments and arguments about the evidence, when you cause the death of someone, the state of Ohio has to determine what's your level of culpability, meaning something, was it negligent? Was it reckless? Was it intentional? Was it purpose? For example, you run a stop sign driving and you hit a pedestrian and they die. Something like that could be negligent. You're coming here to court today, you're going down the interstate 110 miles an hour and you hit a car and somebody dies. Well, you didn't mean for that to happen, but you were certainly probably reckless. You also may have a situation where you get in a car, you see somebody, and you tell yourself, I'm going to hit that person. I'm going to run him over. Then you start to get into an intentional, purposeful act. And then the top of the top, which is not here, but you decide, I know when, where somebody's going to be. I'm going to hunt them down, and I want them to die. And that gets into something much more higher than what we're here today for. My point with this is you can't just focus on the fact that someone is dead. You have to look at their level of culpability, because this level of culpability is in these elements. The judge will give you the instructions on this to make that determination. Toby and Rachelle, they are together 28 years. Some of you jurors may not even be 28 years old, or just a little older than that. That's how long they were together. They're together Michaela's entire life. They're both grandparents together. Their relationship, you heard from witnesses, it's up, it's down, it's hot, it's cold, it's rocky. We even heard about some physical confrontations. Not every relationship is perfect, and certainly this one was not either. You also heard evidence that Toby believed that Rachelle was cheating on him. You also know that Rachelle is trying to renovate Parish. You saw the pictures, you saw the materials, you heard from witnesses. She's trying to get what used to be apparently a drug house people in and out. They're trying to get this together. They're trying to renovate it. And it's not something where she's doing it and she continually kicks Toby out. Toby's there almost every day. You heard evidence, you heard testimony that Toby may be involved on some level with helping this. He's there when she's trying to get the gas fixed. So I submit to you that they're both renovating this Parish Avenue. Maybe to start a different life, the new turn in the relationship, the hot and the cold. Maybe now we're hitting our stride. We're back to good. Let's go to Parish and get this thing together and turn a corner. The neighbors are happy to see them. I know Miss Myers, the bank robber, she comes in, she's Toby's strange. He's a little weird, but he's over there every day. She lets him come into her house, use her phone. She's thrilled to have Rachelle and Toby there because she told you what kind of people were coming in and out of that house. Finally, she has good neighbors. And when she says neighbors, she's referring to Toby and Rachelle. Back to the culpability. All right, so Toby is charged with 2 different types of murder. In Ohio, there's 2 different statutes. The first statute that you can be charged with murder is under Section A. In order to prove that, the state has to prove beyond a reasonable doubt that Mr. Madden purposefully did this. More specifically, that Toby's specific intention was to cause the death of Rachelle. That this is what he wanted. That was his specific intention. Rachelle needs to die. The second way to prove murder in Ohio, the state is charging him in a knowingly manner. It's called felony murder. And as a result of that, you have to prove the culpability. We call it the mens rea, what someone's thinking. They have to prove that he knowingly wanted it to happen. for knowingly. State has to prove beyond a reasonable doubt that Toby was aware of his conduct will probably cause a certain result or will probably be of a certain nature. That he knows what he's doing. That she needs to die. I want her to die. I'm going to do this so she's dead. Party count 2 involves a deadly weapon. We're going to get back to that in a second. But these, I'm assuming the Swiss Army knife, the 2 3-inch tiny Swiss Army knife, I'm assuming that's what they're alleging as the murder weapon, the one with no blood on it. We'll come back to that. So we have these 2 things. We have purpose, we have knowing. Let's think about the evidence here. You didn't hear from Toby, but the state decided to not only play, but talk about what he said here in open court. Nothing could make an attorney more nervous than when a client starts to talk, right? This is what Mr. Madden said. This is the state has put this into evidence. I'm responsible for what happened to her. I didn't mean to do it. I'm so sorry.
Why would you put that up in text form? Because now they can see it and visualize it. That's the part I don't like here.
Love you. I don't want you to hate me. I don't think any witness, law enforcement, neighbor, whoever, didn't deny. Also, Toby was hysterical. He's distraught. He's crying. He can't keep it together. The detective said he was down there for 4 or 5 hours. And he didn't see the video, but he did agree with me. Mr. Madden spends almost all that time just laying on the floor. Hysterical. He's given CPR to Rachelle. State even wants you to think that he's given her CPR after she's even dead. Is there someone who purposely wants someone dead? Why would you even give CPR at the beginning if you've done it? And why would you continue? If she's dead, that's what you want. You leave him alone. You walk out. You get Rachelle's car out front and leave. You walk away. You run from the police.
You walk away.
You don't sit there and continue to give CPR to someone who's dead. That's what you want. What's the point? We're going to get to that.
Yeah, I don't.
What about the gas service guys?
I don't like this. He's not, I get, you don't really have an option here, but this is not how I would have done it, but I get it.
Hey, we come in 8, 9 o'clock, whatever time. Rachelle's got the big dog. We're there to do a job. Nothing seems unusual about us. Rachelle doesn't seem worried, upset, afraid. Heck, it sounds like Toby's asleep in the chair. No worry in the world. Is right there in the chair, maybe woke up and said, "What's up?" We don't hear from them gas workers there's any tension. I mean, I know they're not there to be Dr. Phil or somebody like that, but think about it. If you're a serviceman going in and out of people's houses, you see something wrong, you may walk out and think, something weird about that. I'm here to do the gas, but in your mind, you would remember that. Because they certainly remember the dog, right? The big dog, 2 years. They still remember that. If they saw something unusual, they would have told us. Here's my point with that. That Toby asleep, everything calm. Then, 2, 3 hours later, the state police pull up.
That's the big point I would have hammered on. That's the very big point. The dog was asleep.
It's just, only one computer's connected, so that's sometimes we... 2, 3 hours later, here's what we got. The gas guys went in there, said nothing wrong, didn't see anything wrong. She seemed fine. He was asleep. I didn't see anything on the floor. Police come in. Here's what they see. Also, police pull up 40. Then they see Rachelle there. Broken lamp, furniture on the floor. What do they also find? Police pull up 64. Blood on the windowsill. 67, please. Blood splattered on the wall. So we go from gas workers saying, no problems, everything seemed fine. 2 hours later, we got this. That's what happened. Well, what about motive? Why would he want her dead? The state doesn't have to prove motive. They'll get up here in a minute and probably tell you that. You'll be instructed that they don't have to prove motive.
Motive help.
They don't have to prove it, but guess what?
They ain't got one.
What is it? Where is it? What did we hear?
What is motive?
Why would he want to
Baby,
stab
don't
her?
hurt me. Don't hurt me no
These people
more.
were together this long, and if you believe Miss Cook's story, that Toby Madden continually said he was going to cut her head off and put her head in the lap of grandma, similar to something out of The Godfather. Well, if you do, I'll just say whatever. This Why is that happening? Where's his motive to want to do that? Everything is fine, not even 2 hours before. They're working together on this house, 28 years together. They got grandkids. And remember, we go back to the mental culpability. It's not that she's dead. It's not that her death is caused. It's the mindset, right? Because in the scenario where I run a stop sign and I run someone over and kill him, that's a homicide. Someone's dead. But then when I get in my car and I go, I know where you're going to be. You're going to be at Starbucks at 9 o'clock. I'm going to hunt you down, find you, run you over. Those are both homicides. Those are both scenarios where someone's dead. I've caused the death in both of those. The problem for the state is that you charged him with the highest level. But this is what he wanted. But Toby Madden wanted her dead. If he's continually, again, if you believe Ms. Cook, that he walks around saying, I'm going to cut her head off, put it in mom's lap, wouldn't something have happened before 28 years? I mean, why that day? Because something happened. In those few hours after those gas workers left, something quick happened. There had to be an argument, something, because all that furniture's on the ground. Now, I'm not bringing up Toby's injuries that we're going to see here in any way to try to say that he's a victim. I'm not. If the state would please pull up 82. I'm in no way trying to compare and contrast some of these, what appear to be maybe minor injuries on Toby that the police took. I'm not trying to do that in any way. It is terrible what happened to her. But does this tell us a story about something that may have happened? Because the state wants you to believe Toby, after 28 years, renovating with grandparents together, October 11th is the day Rachelle needs to die. Something happened. Furniture, Toby's injuries while minor, something's going on. We know he thinks she's cheating, right? People told us that. His own daughter told us that. He thought she was cheating. It's hard to imagine that October 11th was the day that Toby just decided Rachelle needs to be done. And I know I've harped on it twice, and I'll harp on it a third time, because don't just look at the fact that there was a death caused. You have to look at the mental element, because the state has to prove beyond a reasonable doubt every element. They have to prove that her death was caused. Absolutely. They also have to prove his mindset. Did he act with purpose? Did he know what he was doing was going to cause her death? If the state could please pull up 149. I believe that the state's claiming that this is a murder weapon. I didn't see, I mean, there was another knife, but it wasn't even analyzed. I mean, Toby, you didn't hear any evidence that he left or anybody else coming in or out. So this is the knife they got. And if this is the, first of all, I submit to you, this is not a deadly weapon, because I don't know if it could inflict the injuries that some of those are. You had officers there for over 9 hours and they went there for 2 days. And this is it. This is the deadly weapon. But it doesn't have any blood on it. It was sent for analysis. Nothing there. I mean, if you're going to stab someone 55 times to the point where intestines are coming out, and it's deep enough to touch the heart. I know I started with the liver, and in the corner said, well, you can get to the liver with this. But then he said something like the heart. It's a little different. The state has to prove to you that he used a deadly weapon. This is what you've been provided. I submit to you that that wasn't even used because there's no evidence that it was. Or DNA or what is the DNA expert talked about something being down inside this Swiss Army knife, but it wasn't blood. 55 times, intestines out, and there ain't any blood on that? You got one detective who said, I went in, it was so unbearable, the smell of alcohol. The next officer said, no, I didn't smell anything at all. Did you hear any testimony that, hey, we went and got Toby from the scene, we were interviewing him, and he smelled of alcohol? Rubbing alcohol, not like liquor, booze. Who else told you that? Nobody. If you're cleaning up the crime scene, as they've claimed, where is all the evidence of this alcohol and stuff? It's not there. And you know what that also does? It proves that he didn't purposely do this, that it wasn't his specific intention. He didn't know that's the result. People who clean up crime scenes, people who leave them, do that stuff. Those are the people who want something done, and they're going to take care of it after. People who want others dead don't stick around to give CPR, and don't give it to the point where someone is dead. Ladies and gentlemen,
he's working on what he's got, chat.
Can't meet these elements. You have to stay focused on the mental element of this. She's dead. It's horrific. It should not have happened, but it did. The element you need to focus on is the mental part of this. because they want to prove to you, and they have to prove to you, that this is what he wanted. And that's simply not the case. Thank you.
And I agree. I don't think they can prove the.
Yes, Your Honor.
Yeah. What did that?
Hey, business honorable court. Good morning, ladies and gentlemen. 55 stab wounds. 55 stab wounds. Head, arms, hands, chest, abdomen, liver, lungs, heart. 55 stab wounds. Ladies and gentlemen, this is personal. This is personal. And again, we heard there was some cross-examination about when they're breaking in, 5 days prior. This isn't some drug coming in and doing this. This is a personal attack that happened. 55 stab wounds. Nobody else came in and did this. It was this defendant right here. Now, the city workers, they had nothing to do with this. It was this defendant. And I submit to you, ladies and gentlemen, this defendant committed purposeful conduct and knowing conduct. And why is that? What did we learn from Catherine Daly from BCI? She told you that this defendant's clothing, the vest that we saw him wearing at Kroger, the gray shirt we saw him wearing at Kroger. What did that have on it? It had Rachelle's blood from those 55 stab wounds. Her blood is on his clothing. And what did he do with it? He hid it. He put it in the basement, in the dark basement. This isn't some accident or anything like that. If he didn't mean to do something, why is he covering it up? Why is he trying to hide his clothing? Where are the shorts? 55 stab wounds. What else does this defendant do? There's nobody else that's in this house. Nobody's coming in. Nobody's getting past Rachelle. Nobody's getting past the dog, putting his clothing on, stabbing her, and then cleaning up afterwards and hiding the clothing. That's not happening. It's this defendant's conduct. What else does this defendant do? He cleans up in the bathroom. Her blood is in the bathroom sink. If you didn't mean to do something, why are you hiding your clothing? Why are you cleaning up afterwards to make it look like it didn't happen there? Why do that? It is purposeful conduct when you stab somebody 55 times. The head, the chest, the arms, the hands. What's the phrase? Death by 1,000 cuts? This defendant sure tried. 55 is a lot, ladies and gentlemen. And Rachelle's screams were so loud. The 74-year-old bank robber that was next door on the front porch heard Rachelle scream for her life. Obviously, you guys are fact finders and truth seekers. You heard her testimony from this witness stand. Is it reasonable to believe that that blood-curdling scream that she heard is coming from Michaela's mother? Your reason, common sense tells you that, ladies and gentlemen. This isn't some accidental conduct by this defendant. He wanted Rachelle to die. What else did this defendant do? His clothing, the gray vest, the gray shirt, washed up the blood. And again, the 12 of you are the fact finders and truth seekers in this case. And I'm not going to put any photos up here on the screen, but look at this stab wounds to Rachelle. Look at the cutting in the clothing of not only Rachelle, but of this defendant. Doesn't it kind of look like that knife that we just had up there, that Swiss Army knife? Doesn't it kind of look like that knife? And where did we find that knife? It wasn't laying there in the middle of the crime scene. We put it in Rachelle's purse, her book bag. If this was some accidental conduct or he didn't mean to do something, why go through all these measures, these methods, to try and hide what it is that happened, to hide the clothing, to wash up the blood, to hide the murder weapon? Why take the time to take the bloody clothing downstairs in the dark? Why? He wanted Rachelle to die on October 11th. Whatever it is that happened, was it something over, I think it was Brian Short, I believe you heard from him on Tuesday morning. He told you, I'm explaining to Rachelle what it is that's going on, what it is that happened, why we couldn't work on the gas lines. And Brian Short, from this witness stand right here, he told you, as I'm explaining this to Rachelle, he's looking right at this defendant right here, giving him a look. You know, Mr. Wilder is correct. I'm going to tell you, I don't have to prove what the motive is in this case. But 55 stab wounds, pretty darn personal. Something happened. 55 stab wounds. How do you not mean to do it when you have 55 stab wounds? One stab wound, maybe you could say you didn't mean to do it. Probably not, but again, maybe. But 55 to the head, the chest, the abdomen, the arms, the hands. Come on, ladies and gentlemen. That is not reasonable. That's not reasonable at all. Why give CPR? Why give chest compressions? Again, defendant is keeping up the ruse and trying to get people to believe that he's not the one to do it. Hiding clothing, washing up the blood, putting the murder weapon back in her purse. Detective Katie Johnson told you when I get there, this woman's honest. The intestines are hanging out of her body. She's pale. He's trying to keep up the ruse that he had nothing to do with this. Defendant told you from his mouth. Safety Exhibit 250. You have a chance to play it back in the jury room. He told his own daughter. The daughter that he and Rachelle had together. This defendant said, I'm responsible for what happened to her. I'm responsible for what happened to her. What happened to her was 55 stab wounds. And that's what he's responsible for, ladies and gentlemen. Ladies and gentlemen, I do want to thank each and every one of you for your time and attention. So I'll say some of the same things that he said. I've been paying attention to each and every one of you. As you're seated over there, you've been paying attention, you've been taking notes, you've been listening to the testimony. Thank you for your patience with me, with some of my computer issues that I had. 55 times. Each time this defendant stabbed Rachelle, she got closer to her death. As Dr. Updegrove told you through those photographs. Each stab wound brought her closer to death. She got butchered in the home that she was renovating. And I ask that you hold this defendant responsible for killing her. Thank you.
Ladies and gentlemen, I want to say that state
Okay,
exhibit.
George, I'm going to ask you to return to the
Oh shit. Okay. Hold on. Toby's talking, guys. I know Kena Casino started tonight on Locals. We will stream snipe them, but we'll get to Kena Casino in a bit. But they got like a 20-minute intro, so here we go.
State exhibit 66 is a stick in there. And I also, if you look at the video of them questioning me down at the police station, if you look at it, they asked me, how did the blood...
I don't think we ever saw a video of them questioning him at the police station. I don't recall seeing that in evidence at all.
...get in the sink. I told them that there was blood on my face after I was doing CPR, and I told them that I went to the sink.
Recess at this time.
Look at...
See, at this point, I'd be trying to turn around like, stop.
State number, exhibit number 66, ask for it back there and see. There's a stick right there. They won't, there's plenty of things they won't bring to you. Ask for it. Right?
You can get there. Okay, now.
Right?
Okay, so.
I know you're not commenting.
The court is not going to tolerate, let me get back on.
You're not, listen,
All right,
what you're not going to do is I'm not going to sit here and allow you to.
Thank you.
This is what you did the last time went on.
It's what you did the last time. The last time what? The last time what? Huh?
You want to come running down the hall this time? You got something to say?
Mr.
Okay, it's going to take us about 10 minutes to get situated for the defendant to appear remotely. I do have copies of the final instructions.
And notice she's not even fucking around like with the way Judge whatever her name was did it. She just straight up Illinois v. Allen, fuck off, next room.
For counsel. We'll share those at this time. And the court will need to read an instruction to the jurors as to why he is not in the room.
Yes. There was a stick and had a watermark on it. Eric July planted it there. All right, so let's
We're going to take that straight out of the Ohio Jury Instructions Manual. Once we are ready to go upstairs, we will proceed. But
all right, so
counsel wants to review that and be guilty.
Okay, we're gonna skip the jury instructions, chat. There's no point in being here. The verdict comes in. We're gonna get to these interesting parts here, though, if you guys are ready for the rest of it. Yes. As we said, based Ohio lets the defendant tell the judge what to do. Yeah. No, that's not how it works. Anyway, here we go.
In this building, and he is able to hear these proceedings. Okay, so I've been advised that the jury has a verdict. However, some concerns were brought to my attention during the recess that I'd like to address at this time, and I'd like to ask Sergeant Owens to please take the witness stand.
The jury is basically out about an hour or so. We're going to speed him up just a hair.
Sergeant, would you please state your name?
Sergeant Jason Owens.
And what is your occupation, sir?
I'm a sergeant with the Butler County Sheriff's Office.
And what are your present duties?
I'm the supervisor over court security.
And Sergeant, in your capacity, did you have the opportunity to go to the remote location where Mr. Madden is viewing these proceedings?
Yes, I did.
And at any point while you were present with Mr. Madden, did he make any statements that caused you concern about his return to this courtroom?
Yes, he advised his attorney that if he were not wearing restraints, that his attorney was lucky that he was currently wearing restraints, implying that he would inflict physical harm if he were not.
And did Mr. Madden advise in your presence whether he even wanted to return to this courtroom?
He advised my personnel that he did not wish to return.
All right, very well. Anything on behalf of the state? Okay, Mr. Wilder, any questions that you have?
No.
Okay, thank you, Sergeant. You may step down. In light of the sergeant's testimony, I'm going to continue to have Mr. Madden participate in the proceedings outside of this courtroom.
Yes, Your Honor.
Okay. All right. So I understand the jury has reached a verdict, and we are waiting on the state's representative.
You should be here momentarily.
Okay. Well, we'll go off the record for just a moment.
I mean, to be fair, it's like, well, I can't really say no, Judge. I want him here, so I want to get my ass kicked. You're kind of stuck. I mean, that is a bit of an issue there. I mean, that's I've sat there next to people and I thought they were going to lose their shit. And I've been in a case before where the bailiffs or the court deputies were like, dude, we thought he was going to jump you. And I'm like, maybe he would, but like, there's nothing I could do. I'm not going to fuck his case up like that. Oh, he woke up. He woke up. Look at him. He's like, oh, why is he not there? There he is. Oh, he's like, I'm sleepy. Yeah, guys, the code not guilty should be the code for locals. Anyways, let's get back to this.
Mr. Halpin. Murder is charged in the form number 1. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 2. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of murder as charged in the indictment. The verdict form is signed in ink by all 12 jurors. Verdict form 3. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. The verdict form is signed in ink by all 12 jurors. And finally, verdict form 4. We, the jury, being duly impaneled, find the defendant, Toby Madden, guilty of felonious assault as charged in the indictment. And the verdict form is signed in ink by all 12 jurors. Okay. Does the state of Ohio wish to have the jury polled?
No, Your Honor, thank you.
On behalf of the defendant, do you wish to have the jury polled, Mr. Wilder?
Now, guys, you're wondering, how can we charge? You could be found guilty of all 4, but you can only be sentenced. You can't be sentenced on all 4.
Wow.
No, thank you.
Okay, ladies and gentlemen, I want to thank you for your attention in this matter, and I appreciate your.
But because it's murder, it's automatically a 15-year minimum mandatory, 15 to life sentence. So they're going to go straight to sentencing from here.
Patience with us during some of the breaks that we had to have, and the concentration that you had throughout these proceedings. And on behalf of the public, I want to express my sincere appreciation for your services in performing this most important function. The judicial system, as we know it in the United States, is failure to enroll or failure to verify provide
Here you
enroll.
So here is the violent offender thing. If you guys haven't seen this before,
30207, so I would ask the court to find Toby Madden to be able to
sorry.
I would like to put on the record with regards to that.
I think I put on the record, I did file notice of intent to use certified convictions proof of the prior conviction. That was filed on January 11th, 2024. There's a felonious assault conviction, aggravated assault, which I don't think that part counts. It is the felonious assault is account for. It's in CR 88030207, so I would ask the court to find Toby Madden to be able to be violent offender.
Any argument on that, Mr. Wilder?
No, Judge. Thank
Okay.
you.
All right. The court has carefully reviewed the exhibit and is going to find Mr. Madden guilty of that specification and will find that he is a repeat violent offender. Okay. The next thing that I need to ask is everyone to
A repeat violent offender is a sentencing enhancement. So he has prior felony convictions of violence.
prepare to go forward with sentencing this afternoon.
Yes, Your Honor, thank you.
Yes, Judge.
Okay. All right. Before we proceed to that, the conviction will require that Mr. Madden enroll as a violent offender pursuant to Ohio Revised Code 2903.41. And of course, we can continue that hearing. The basis for rebutting that, the presumption that the court place him on that registration would be that he is not the principal offender. I haven't heard any testimony that would suggest that that would be necessary. Mr. Wilder, do you oppose going forward today?
I would agree with that. No opposition to going forward. Thank you.
All right. So I'm going to give Mr. Madden some advisements, and there will be a form that I'll ask the deputies to have him sign so that he can have a copy of it when we've concluded our hearing. Sir, you have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in Ohio Revised Code section 2903.41. If you are not sentenced to a prison term, you are required to enroll in the violent offender database personally with the sheriff of the county in which you reside 10 days after being sentenced. If you were sentenced to a prison term, you must enroll in the database personally with the sheriff of the county in which you reside 10 days after release from jail. If you are an out-of-state offender, you must enroll in the database personally with the sheriff of the county in which you reside or occupy a dwelling within 10 days of either 1, residing or occupying in a dwelling in Ohio for more than 3 consecutive days, or 2, residing in or occupying a dwelling in Ohio for an aggregate period in a calendar year of 14 or more days. You are required to provide to the sheriff certain information, including your full name and alias you use, your residence address, your social security number, any driver's license number or commercial driver's license number or state identification card number issued to you, information regarding the offense of which you were convicted or pleaded guilty, the name and address of any place where you are employed, the name and address of any school or institution of higher education you attend, the license plate number of each vehicle owned or operated by you or registered in your name, the vehicle identification number of each vehicle, and a description of each vehicle, a description of any scars, tattoos, or other distinguishing marks on your person. You are required to provide the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of enrollment. After the date of initial enrollment, you are required to re-enroll annually. You must update.
Now, I think this is nonsense. Like, we have a sex offender registry, a violent offender registry, and we have like an arson registry. Like, some of this shit is ridiculous to me personally.
And or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you were initially enrolled.
So anyway,
Madden will fade into the past for me and my family. There are or not a second mother.
Make the decisions that I have the authority to make. And I'm sorry for your loss.
I know there's maybe 3 officers that testified, but there are many more that were part of this case, and justice would not have been served today without all their efforts. So thank you.
Very well. All right. The court has considered the purposes and principles of sentencing in Revised Code Section 292911 and the seriousness and recidivism factors in Revised Code Section 2929.
Well, wait, where the hell does Toby talk? I thought they brought him back in for sentencing. Let me see if he talks at all. They must have let him talk at the beginning.
To the audio being,
yes, sir.
No objection to that. I would, if I may.
You may. Yes, sir.
Without getting into specifics, obviously honoring the attorney-client privilege that I've held with Mr. Madden for 9 months, I can say that the specifics of the before, during, and after were never brought to my attention. Thank you.
Thank you. Okay, so at this time, if there are any victims represented.
Specifics.
Did he get? Oh yeah, here we go.
Give you how I should sentence you.
Well, I just want you to know that.
Here's Toby Madden talking, guys. Sorry, we had to find him for a second. Do you have a registry for your wedding? Not yet, no.
To my family. You know, all the years, if it didn't please you to know that somebody is I don't presume to know the pain that you're going through. I don't presume to know the pain that you're going through, but and I don't understand it. But I can tell you, you don't know the pain that I'm going through, knowing that I'm the one that caused this tragedy. And if there's any solace, there's any silver lining in knowing that when I go to bed, that's on my mind. When I wake up in the morning, that's on my mind. When I think about SeaWorld in San Diego, I think about walking on the beach in Florida, the chalet in Gothenburg in February. I think about all the years, all the meals that we've had together, the Christmases, the Thanksgivings.
Well, guess what you're not doing anymore?
These feelings, these emotions are
All right. It appears the audio has been turned off at this time. Any objections to that, Mr. Wilder?
Which is, how do they, that's an issue. They shut his audio off. He hasn't done anything wrong yet. That's a problem there. That actually is a problem, in my opinion, chat. So, it's a big problem to me.
Yes, sir.
No objection to that. I would, if I may.
You may. Yes, sir.
Without getting into specifics, obviously honoring the attorney-client privilege that I've held with Mr. Madden for 9 months. I can say that the specifics of the before, during, and after were never brought to my attention.
Okay.
Thank you.
Now let's get to.
And what was Judge Stevens' case number?
All right, here we go.
Convicted of is on the exhibit so gruesome in the court 15 years in prison.
Here we go.
All right. The court has considered the purposes
All right, this is the sentencing. Here we go.
principles of sentencing in revised code section 292911 and the seriousness and recidivism factors in revised code section 292912, as well as the penalties that are statutory penalties that are associated with the offense and the specification. The court is also considering the record and the charge and the statements made at this hearing. And the court on count 1 is going to impose the mandatory sentence of an indefinite mandatory minimum term of 15 years in prison and a maximum term of life imprisonment in the Ohio Department of Rehabilitation and Correction. As to the repeat violent offender specification, the court is going to impose 10 years, and it will be consecutive to the sentence. The court is imposing the maximum of 10 years because this offense was, quite frankly, so gruesome. The court finds that the defendant is a danger to the public, and the court relies on the Exhibit 251 and the offenses that.
So the RVO specification is a 10-year sentence on top, and she can max it out, and she did for him. So he's got to serve the 15 years and then 10 more, and then he's eligible for parole.
Mr. Madden has previously been convicted of in support of those findings. The court is going to run this sentence in this case consecutive to the sentence in case number CR 22101423, and the court is running it consecutive because it believes that consecutive sentences are necessary to protect the public from future crime and to punish the offender.
Ooh, I forgot about that. Shocker, he already has well, we'll get to this. So he's got another bit of time. He's got another case. We'll get to that.
The court further finds that consecutive sentences are not disproportionate to the seriousness of the offender's conduct and to the danger that he poses to the public. And the court finds that the offender's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the offender. The court is also going to impose court costs as a part of the sentence, and the court will award 316 days of jail time credit. Are there any other findings that the state wishes for the court to make at this time?
So it's 15 years to life. The RVO is consecutive. I think that's by clause. And any sentence on the RVO is consecutive. And what was Judge Stevens' case number?
That is a CR 22101423.
I don't believe there's anything else wrong with me.
Okay. Anything on behalf of the defendant?
Sure. Judge, I don't know if this is required or not. Should there be any advisement at all about PRC at all, given the sentence? May not. I was just making sure we're clear before we left.
My understanding that it does not because of the indefinite nature of the sentence, the defendant would be subject to parole rather than post-release control.
Remember I told you guys that in Ohio, when you commit murder, you get put on parole, and parole is forever.
State have any objection to the court's findings? Okay.
Nothing further than.
And then the final thing that I would indicate that this defendant does have a right of appeal, and he has 30 days from the date that the conviction entry is filed to file that notice of appeal.
I will file that for him, understanding that he will have to do it with Attorney Willoughby.
Yes, sir. All right. Well, again, I thank counsel for their professionalism, and at this time we will recess.
Okay, so that's it. That is it for Toby. So Toby got 15 years to life for murder in Ohio. That is how it's set up. It's a minimum mandatory 15 years with a potential life sentence. And then what we talked about before, in Ohio, after 15 years, you're eligible for parole, and the parole board can assess you. You then saw he got 10 more years consecutive for repeat violent offender. So that's 10 on top of 15. So he's got 25 to life. And then she said consecutive to another sentence he has. And that sentence is another 10 years. I'm sorry, it's 11 years. So it's 36 years to life in prison. And if you guys wanted to see that one, here's part of the issue for good old Toby. This is Toby's thing in the Ohio Department of Corrections. He's already serving an 11-year sentence for first-degree possession of drugs, which means he had to have a shitload of drugs. A shitload. And he has a minimum mandatory sentence of 11. He has a minimum sentence of 11 years, and it's mandatory in Ohio because in Ohio, mandatory time. The 16 and a half year thing is if he violates the rules of prison and acts like a dickhead, they can extend his sentence up to 1/2 of the original sentence. But initially, he's not eligible for parole until 2033. But remember, he's got 25 more years to serve. So he won't be eligible for parole until 2058. 2058. So he's got a long way to go. Yeah, he had a lot. Oh, he did. Hold on here. Is that really? Hold on here. Butler County Clerk of Court. Let's see here. Because he did have a case there. And 300 grams of meth would definitely do it. All right. Let's see what this indictment is. It doesn't say exactly where he had it, but yeah, he definitely had a lot of meth. First degree meth possession is a lot. It's a shitload of meth. So yeah, he's got a lot of problems. He's not getting out anytime soon. So yeah, I mean, like it's hard to figure out what happened here for him, but yeah. So yeah, Paul Goodyear's right. He was married 28 years and now is 25 plus in prison. Yes. Get to these super chats and comments real quick. Kia Patrick saying, been debating to send you a Metal Gear Rex model. That'd be cool to do. I'll do a Metal Gear. Logical Bystanders, his online training videos have watermarks on them. Maybe. City Darkheart says, love the Laney and Clyde cam. Well, thank you. Your pager joke was fire, Sean. Well, thank you. I tried. Brandon Lesko for $4.99 says proof of Clyde. Well, I think we've got that going. We've got that going right there. Proof of Clyde. He looks tired. You wonder if this guy's model building skills is as good as mine. Probably not. Probably not. Bifront says, rip Pete Rose and Dikembe Mutombo. Yes. Brittany says, you got to do that for your next closing. Which part? I don't know what you mean. Sorry. Overall, his closing wasn't bad. Dagamore says, are you going to exchange matching 1911s to 38 Super? Or was that my wife and I? I mean, that would be fun, but I don't know if that's 2.0's cup of tea. But that would be a lot of fun. That would be a lot of fun. Does Ohio have a system we have good behavior for release? Well, that's part of the parole system. Now, in Ohio, you also heard them say post-release control. Post-release control is what we used to call parole for everybody, but post-control is different, that it's a set amount of time. So in Ohio, for various types of crimes, you might be subject up to 3 years of post-release control. And the way post-release control works in Ohio is, so for like 3 years, is 1,095 days. You get released on parole, PRC, post-release control. Your clock starts ticking down. If you're on post-release control and you get a new felony charge, and by the time you're sentenced, you are subject to that new felony time plus however much time's left on your PRC clock. So if you had 800 days left, you get 800 days plus your new felony time. If you have less than a year of PRC time left, you automatically get a year of PRC time. So you could have 10 days left and bam, you get hit with another year. I've had that happen to clients before. 30 days left and they get nuked for, 11 extra months. Now, that said, though, the judges could do whatever they want. And I had a case where a guy got a felony assault. He beat the fuck out of a lady. She probably deserved it. He had post-release control time. He had like 2.5 years of it. I got him pled down to a misdemeanor. Judge did him a solid, and he says, I sentenced you to 1 day of post-release control. Because he sentenced him to 1 day of post-release control, the judge short-circuited the ability of the parole board to fuck him over with the extra 2 years. So, yeah. Yeah. And so Benjamin Lewis says, fuck being on papers. Yeah, being on papers is rough. Cedar Rose says, just want to say that for 5 loonies, I want to say I appreciate you read the comments in chat and not just super chats. Much respect. Well, of course. We've got to. We've got to out there. I take a good sense as a solid judge. Oh, Judge Michael Goulding in Lucas County, Ohio. Very good judge. Phenomenal judge. That said, though, if you commit a crime and there's fucking old people involved, you are fucked in front of him. Although most judges will fuck you. So, yeah, guys, so that's it here. We are all caught up. Toby Madden. We'll probably get ready for Sarah Boone starting next week. We'll get her ready because that's going to happen. And, yeah. Well, I know many YouTubers don't, but I'm not many YouTubers. I mean, we also get, doggos for free. Diane says, thanks for reading the non-super chats in the Kamala economy. I'd read them anyway. Because just because you don't super chat doesn't mean it's not worth noticing. Night stream later. No, guys, we are going over to locals. We got to get over there. 1 month free at locals. Promo code POTCRIM. Join us over there. We're going to do it up over there. Did I miss Paul's super chat? Oh, Paul. Sorry, Paul. I missed this. Sorry. I am so sorry, Paul. It says, Paul, for 2 Canadian loonies or 1 Canadian toonie as a little thanks. Yes. Well, thank you, Paul. I appreciate that very, very much. I appreciate the thanks. PotCrim is saying about, I put down for like 500 people to use PotCrim. What the fuck? All right, fine. Tonight, guys, we're not gonna paywall the stream. We're gonna do it live in front of everybody. Come over and join us for free over on locals. We're gonna let everybody see it tonight. I don't know why the thing's not working, but I don't want to fuck you guys over. So let's go snipe the casino, chat. And I will see you guys tomorrow. And remember, apparently Toby Madden did it, and apparently he's really fucking guilty. Just saying. Just saying. And for the next 35 years. Good night, chat. Take care. I'll see you guys over at locals. Remember, everyone's going to come over. We're going to run it free tonight.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the